Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
Good morning. Happy Monday to you. Welcome to the Court of Public Opinion. My name is Recovery Addict, and I don't fit in my box again today. There we go. A little bit. Adjust the chair slightly. Good to have you here. Just trying to see. Something's not right, and I don't know what it is. If you guys can spot the difference. Well, it'll come to me somewhere. Welcome. Good to have you all here. Hope you had a fabulous weekend. Hope everything's going well for you, especially for Adam. Adam Nusky, first in chat this morning, says, JJ, I'm not sure what he was trying to type, but it doesn't really matter. Just being first in chat is enough. Adam, you have won the internet for the day with that JJ, which I'm curious. You'll have to explain what the goal was, or if it was just mash the keyboard as fast as you can. Either way, it worked. Congratulations, Adam. The internet is all yours for the day. Please take care of it. If you choose to rename it, just tell us what you're going to call it so we know what to call it when we look for it. Let's see. We've got a few other people here. 6-Volt Bus, Sharon McDonald, Dallas Born, Boston Bred. Good to see you. Oh, there. I'll start clicking the names there. That'll be better. Norma. There's 6-Volt. Sharon. K-Frame, good morning to you. O-Town Chill, good morning. Not a drama llama. Good morning, friends. It's been a long 2 days without you. It's been a miserable 2 days. I tell you, it's been miserable. It's awful. I hope you had a good weekend, drama llama. Not a drama llama. I have to shorten that somehow, but if I shorten it, it sort of reverses your name. I'm not sure what to do there. H-Frame, good morning to you. Victoria S. Amber, good morning. Hope you had a good weekend as well. Maryland School. Missy Pants, good morning. Happy Monday. It's a wonderful Monday. Misty Farley, Toxic Orchid is here. We've got a couple mods in chat. We can start now. Golden Girl, Mac, Linda Hill, Terry Korhoniak, Richard, Murdoch Sensing. I don't think so. Let's see. Denise, Linda, 6-Volt. We've got a few more. Ritz, Michael Ruddle. Sorry, I'm getting your letters mixed up there. Golden Mom 513.
I'm not a camel. We have a new court case, by the way, today. I tried very, very hard. I reached out to Creighton Waters to get him on the show, just to talk to him. And let's see if this works here. Sorry, I can't show you guys my password. And he did not respond, unfortunately. I was a little disappointed, but he. For those that don't know, Mr. Waters is in the front. You know, he's like a cover band. He plays the guitar, and I think he sings as well. Although I haven't really watched enough of it to know, but he plays the guitar and he can shred a little bit. He can jam. It's more old school type stuff. And so he posted a video over the weekend of him just jamming on the guitar. I asked his permission to use it because it was an original composition. And he didn't respond. I'm sure he would have been okay with it, but out of respect to the musicians, I'm not just going to take that and share that. But it had like lasers and like colored lights in the background, so I'm like, it's worth looking up if you want to see that. Check that out on Twitter. Let's see, Warflare's here. Ritz, let's see, Denise Feldman Ersland, good morning. Misty Farley, got you there. Shells, hello. Clipson's Vixen, Toxic Orchid, 6-Volt Bus, Ritz, Tater Tot, good morning. Golden Girl, TW. Holly Henderson. Too many H's today. I just can't get it out. Holly Henderson is here. Samantha Terry, good morning. Joelle, Kathy, got you. Miss Chris, I think got you before. KQD says, good morning. Weather update, 28.0 degrees Fahrenheit in my front yard with just over an inch of snow. And I think you guys are getting some more. Last time I checked, your state was pretty much solidly over 100% snowpack over the entire state. But it could be worse. Look at California. You know, they're sitting in a lot of snow. Let's see. Who else here? Suyan. Is that right? Suyan? Ready Freddy GG, Georgia Culture, Mary Kay, Lily Georgieva. Got it, Lily. I said it right this time. Misty Farley. Let's see. I think I miss every time I try to scroll down a little bit, it jumps. Hannah Gordon, KX Star, Ice Cream Man Double Murder Trial is on. We've got a different one to watch, and it's sort of spicy. Not in like a Jensen type spicy. This trial that we're going to be picking up today is spicy because of the lawyers, because of the interaction, because of the heated interactions, and how much they object, and how they object, and the language they use, and just the fiery passion that exists. And we've lacked that. Harpootlian did not deliver that, and Mr. Waters didn't deliver that as well. So I think that'll be good. As far as the crime itself and the evidence, I'm not sure if that's going to be as intriguing as some of the other crimes we followed. There's no body in this case. They have not found the body, but they are charging for murder anyway. So let's see. Rianne K, Shelly Belly, you better go hit the like button real quick. Red Pen Minsky, good morning to you. Janet Matson, Last Poet. Tony Fortune, Hannah, Twisted Branches, Kayla Williams, Warflare, Illinois Mama, Janice Ashley, Ritz, we got you, Twisted Branches, KQD, 7, Kevin, I like when they rhyme. My Dog Murray, Old Dude, good morning to you. I'm almost there, I think. I'm catching up. That or my chat's not working right. Adam Nusky, you on the internet, you can't leave. Gordon, Krob, welcome. Melissa, Maggie Carr. I feel like a couple of you have changed your names over the weekend. Am I wrong here? Am I off base? I think a few of you might have just changed your YouTube handle. MM Jones, welcome. Horse Sheet and Bananas is here. Queen Olive as well. Not a Dramalana. Nana Geek, good to have you. Marcy C. Let's see, Lee, did you offer him free pickles? I should have. Maybe that would have sweetened the deal enough to get him on the show. But Michelle Johnson, Last Poet, Lee, DMB Secondist. I did reach out to Mandy Churchwell again, and she's basically saying I'm taking a little bit of a break because I've been just slammed with all this attention and stuff as she did the Churchwell chart. And I want to talk to her actually about what's coming up next for her, and I think it's going to be really useful. She's really good at documenting times, just all the little details that come out in evidence that it's hard to put together without notes. Well, she puts it in notes and then puts it together in a way that's easy to understand, as you saw in the last trial. And she's looking now at the BK case, and that's going to be a lot of fun because we've got a lot of similar things. We've got cell phone pings, we've got different data points, cameras, intersections, things like that. So that's going to be useful to look at. So I wanted to talk to her about that. But she says she's taking a little bit of a break. She was in Florida on the beach over the weekend. So maybe this week we might connect with her, or maybe wait a little bit longer, closer to the BK case. I'm not sure. Samantha Terry, Jen Hoff, Sozi, Nurglerot. Hey, Eric, good to have you here. Key N, True Celtic Mutt, welcome to you and the Gavel Hounds as well. Let's see, Ritz, Lee, JK, DMB Secondist. Why is it always Wisconsin? I swear I'm never setting foot in that state. Let's see, top of the morning to you, Mutt, Ann Schatcher. Coop, Ginger Meadows. Oh, man, I thought I was caught up. It's going too fast. Yes, Man Bun for the win is what we have in this trial. It takes us right back to the Alexander shot in the foot guy. It's like spitting image. It's like they were twins separated at birth. Donna Thompson, Tony Fortune, Adam Nusky. He plays 80s rock. Yes, he does. Like he gets into the Eagles, some older stuff, but it's pretty good. Vairi, welcome. Ola. Flobby Jobby, Sandy Fields, Canned Laughter, Lynn Hoke, good morning to you. Carl Hersel, Last Poet. Appreciate the poem you made last week, Last Poet. That was fun. I've never had somebody write a poem about a court case we were covering before, and that was cool. I think you can still find it. It's one of the comments on one of the videos. I might have to find out when it's at. Sassy Girls here, Ritz, Carl Hersel, we mentioned you. Abby UK, hugs to you. Babs09, GMA Nobby. Sam, the defense lawyer woman, is so unlikable in this case, and that's what I like about it, Sam. It's easier to like or dislike the lawyers than it is to like or dislike the defendants and the witnesses. The witnesses, obviously, they have to be there. They're subpoenaed. The defendant, arguably is either innocent or guilty, and you can choose a side on that during the trial. But the lawyers, they're fair game. Sorry, Matthew and Nicole and everyone else who's out there who's in the legal profession. But as just observers, we get to really to pick on the lawyers a little bit and decide whether we like them or not by how they perform. Ritz, Mo, Upper Torso, Samantha Terry, Ritz, Gordon, Pampered Glamper, Red Pan, Rhonda, Misty Farley, Sharon McDonald. Good morning to JB. Yes, JB and Ronnie as well. Both of you. Good morning to you. Michelle Richardson, Giant Rat that makes all the rules. Hold your horses is. I think it's funny that horse sheet and bananas is followed immediately by hold your horses. It's nice to see you next to each other. Bone Digger 64, Debbie, Natural Empress. I think that's almost all. Sari Morley, sorry I missed you. JR, see you as well. Veronica Reyes, last trial was so emotional I cried several times. Yeah, this one probably not so much. Let's see, Marcy. Okay. Lee, Ivan, Victor, another Wisconsin. I swear it's not that crazy here. It's always the southeast part of the state, never up north. Okay, Dutch Girl. I was just watching the trial this weekend. Okay, let me tell you, Dutch Girl, since you brought it up, the trial started before the last trial ended, and I went through and I figured if we were just start watching now and just pick it up with live, which is I believe starting today this morning, we would miss a ton. So I went back and I've watched all the trial, and there are some huge gaps. There's some huge breaks. A lot of deliberation. There are days that are cut early. Some days they were only there for 20 minutes, and then the rest of the day they're gone, and things like that. So what I want to do is I want to watch the clips that will bring us up to speed. Specifically, I want to watch the opening statements of the two parties, which had a huge interruption in the middle of one of them, which we want to find out about because that's going to be a big factor in this case. Almost like mistrial type level. That word gets thrown around before the opening statements are even done. And so it's going to be a blast to follow that. But we are going to get up to speed, and eventually, before the trial's over, we're going to be caught up. It's going to take a little bit of homework on my part to research and cut out the breaks because I have to know how long they are and skip around a little bit. But if you guys will be patient with me, I don't want to watch it really at a fast speed because I think some of us, me specifically, I have a hard time gathering all the data and information and letting it really percolate and sift down to where I need to understand it at a higher speed. So unless it gets really slow, I don't think I'm going to speed it up. A couple more people here. Let's see. Yes, this courthouse is the Rittenhouse judge, and for some reason his name just escapes me. I need to know what his name is, but it's just gone for some reason. It's the judge who drives me nuts. He talks a lot. Sometimes that's what introduces so much of the bizarreness into it. It's crazy. Okay, I noticed I've got a problem with one of my items here. Just 1 second. Alerts. There's that one. Hold on just 1 second as I fix my computer. Okay. Let's go up to the top. I thought the chats are not working properly. So just 1 second. Okay, here we go, right here.
6-volt bus just sent a super sticker with 4.
Thank you very much, 6-volt. I apologize. I saw that come in and realized immediately that I still had the audio turned off from over on the podcast. Anyway, I think I got just about everyone. Susan Blankenship, Mermaid Lagoon, Elise Soliel. Watched the videos over the weekend. It's really strange how this court operates. It is weird. But at least they stand for the jury. Samantha Terry, Wendy, wait till the end, so you'll see me amidst all the chatty people. I see you now, Wendy. Weather Watch, good morning, Thomas. Hope you had a great weekend. Thanks for the awesome podcast on Friday. If you those of you that missed it, it was awesome. It was a good one. Jojo Peter, Morton Anderson, Rev Minister. Gordon. I think I've got everyone. Jojo Peter, I see you there. Ginger Meadows, Dutch Girl. Keisha B, good morning. Lisa B as well. Cajun Girl, Carol Martin, Miss L. I am Ami. I think I got everyone. Okay, so I'm Holly. I'm live now. I think I was pretty sure I'm live. If you cannot hear me, that might be a problem. Okay, Dilly Pickles, everybody. Okay, so let's do this. Let's go ahead and start. Let's see if we can bring. Where I'm going to start, we're starting right as the court clerk is swearing in the jury. So the members of jury are there. We're going to learn the names of the lawyers and the defendants and the girlfriend whose boyfriend was murdered and everything as we're going. Chats aren't shown on screen. Thank you very much for that. Fixed it. I did not see the 3 jurors on the Today Show. That would be interesting to hear what they say. Will we recap this case we'll see today? I don't know anything about it. Sorry. That's what we're doing. We're actually going back and watching the opening statements because that will tell us basically everything the prosecution says, as well as give us an idea of what's coming up, and everything the defense says, as well as an idea of what's coming up on their side. That will really set the stage for us, so we can just watch this and not have to go back and research and retell the story over and over. The defense attorney is fierce. I believe she was listed in the top 40 under 40 lawyers in America. She's very, very feisty. So feisty is probably a better word than spicy. Sorry, what trial? This is the Wisconsin versus Zachariah Anderson trial. So here's what we're going to do.
Zachariah Anderson, the defendant, and unless discharged by the court, give a true verdict according to the evidence given in court. So help you God?
The audio starts out poorly, and it gets better as the days go on.
Okay, folks, we'll hear now the opening statements of at least the district attorney, perhaps both parties. Sometimes you'll hear the actor or actress judges on TV talk about opening argument.
So the jury's off to our right.
There's no such thing. These are opening statements. They're intended to be brief roadmap, I guess, to highlight for you things that the party explaining what it is expected will be proved, and the district attorney will lead off, and after he's completed his remarks, then the defense has the opportunity to make opening statement now, or if it is preferred by the defense, they can reserve opening statement until a later point in the trial. Again, they're not intended to be argument. That'll come at the end, the closing arguments. And then the lawyers will be trying to convince you, well, of course they're always trying to convince you, but they're going to be exhorting you to come to a specific verdict. But these should be generally expected to be brief and informative.
That's our defendant right there. That's Zachariah Anderson.
And with that, Mr. Gravely, if you're prepared, you may make your opening statement.
Mr. Greeley or Mr. Grayley? I'm not sure what his name is.
Ladies and gentlemen, Judge, ladies and gentlemen of the panel, thank you, first of all, for all your service. Can everybody hear me very well so far?
We can hear you.
This will be several days. There'll be a lot of difficult and some emotional testimony, and I just wanted to thank you in advance for the time and effort and attention you're going to put in this case. This case has a lot of moving parts, and so though the judge has asked that it be brief in his discussion with you, I fear that I need to cover a number of things with you, so I'm going to take the time that I believe that the evidence demands to try to give you a roadmap as to what I believe you will hear in terms of evidence in this case. I start with what I understand Sadie Beecham will share with you. Sadie Beecham, I think, will tell you that on May 17th,
I dropped killer, got pushed off.
She felt her life was finally about to change. She had.
Okay, Sadie Beecham. It keeps cutting out a little bit at the beginning. But Sadie Beecham is the girlfriend
in 2012. So this was 8 years later since she had last lived with him on a regular basis. They had 3 children together. She will tell you that he basically came and went as he pleased. He had a different household. He did not pay.
This is so
On
frustrating.
any kind of regular basis. Sometimes he showed up on weekends, and yet he expected and anticipated that they were in a relationship and that simply was going to be enough. In December of 2018, she didn't want to live that way anymore. And so for a variety of reasons, they broke up. And so that relationship, that separate houses, you come when you want, when you mess up, you just beg me for forgiveness or do a gesture that tries to get the same situation where you're always in control, was going to be over. And so for a few weeks, they didn't have any contact. And then slowly but surely, the defendant wanted to have visits with his kids, which of course was fine with her, and he was able to get back in touch with her on a regular basis, trying to get back together with her, again trying the cycle of trying to get forgiveness and everything will change. But this time she wasn't going there. It doesn't mean she wasn't nice to him. It doesn't mean there weren't times where she tried out of kindness to explain why this relationship was not happening. It doesn't mean she didn't have feelings for him in some way, shape, or form based on their history. But she was ready to move on. And by February 17th of 2020, she was on a dating site, and she met somebody where she thought maybe this will go somewhere. The person she was in contact with was Rosalio Gutierrez. Now, he was from Kenosha, so there was that was a drive to sort of see what she was going to be able to make of this. But he seemed to love his kids and to have a relationship with his kids, and she liked that it might go somewhere. Now, this is the early weeks of this maybe relationship, right? It's not exclusive. And so she doesn't feel like she wants to share that yet with her 11-year-old who turns 12. And she certainly doesn't want to share it with the defendant, who is her ex. She knows him, and
the video keeps
right in the sense that what I'm going to talk about next in the evidence, I'm going to ask you to look for a certain pattern. I'm going to ask you to consider whether the defendant, as I outline the next grouping of incidents, is an individual who shows by each of these incidents that he is overwhelmed with jealousy. You'll hear a number of communications where that is clear even from his own mouth. And that he has an overwhelming need in that jealousy to be in absolute control when it comes to Satan. Each of these incidences can be characterized as a gesture where he demands control, and as he loses control, we'll talk about what the evidence shows comes next. More and more irrational each time, more and more disturbing. And then I'm going to ask you to take a look at whether the defendant in each of these incidences shows you his determination to have absolute control by using every tool available. Using human spies, a person named Steve Lentz, he texts
human spies
as a lookout for him. Age 11 and 12 will tell you I was recruited by him as essentially a spy. And that he's willing to use electronics too. Basically every way you can spy on another individual, the defendant was employing in regards to Sadie Beecham. So let's talk about each of those incidences briefly. April 24th, and this is just a 1-month period where the defendant slowly but surely learns no matter not get control.
This gets better.
And so what culminates at the end of that about a month-long period is Rosalio Gutierrez no longer being alive to anybody who cares about him, to anybody who knows him. So I start with April 24th. The defendant has his 3 children with Sadie at his house. So he has his 11-year-old daughter, whose birthday is going to be the next day, and his 2 4-year-old twins at his home. He is the only adult there. Sadie does not have the kids on that day. So what Sadie does is invites her new relationship Rosalio to come over to her home. She has no children there. She's a consenting adult whose children are at their father's. She invites Rosalio to her home. In the middle of the night, she's awoken. She's awoken because her doorbell rings. She looks out and she sees a vehicle that looks like a vehicle that the defendant owns squealing away. The next day, Rosalio and her discover that Rosalio's truck has been entered. A letter has been taken from that truck, as well as his car registration, a registration that has his stepfather's name signed on it as the person who signed, I believe, the title, the registration. That's missing from Rosalio's truck.
It's getting better.
The 11-year-old daughter then, by the time police talk to her, she is 12, says that in the middle of the night, she went with her father to the home of her mother, who she normally lives with, Sadie, that her father peeks in the windows at that location. The daughter says the two twins, age 4, are left at his house unsupervised. She actually says, I didn't feel that was safe. She says her father, the defendant, gets the paperwork out of this person's truck. She says her father, the defendant, takes a listening device and puts it in a vent at her mother's home. She says that he summons her over, and she is encouraged to look inside the window of her mother's home. And at that time, she sees her mother and a person she's never met, she hasn't seen before, who she now believes to be Rosalio, in that, I believe, living room of her house through the window. Her father's instructions are, be sure you don't steam the window up because they might be able to see it. This is the middle of the night for an 11-year-old girl the day before her birthday, when a rational mind might be making sure everybody had a really good night's sleep, anticipating a party or a celebration the next day. This is how the defendant chooses to conduct himself. He admits to law enforcement that he had a premonition that something was going on over there, and not only does he admit he went there, but he admits that he encouraged or helped his daughter look in that window. He denies that he put a listening device in. He denies he left the 4-year-old twins behind. He says he brought them along in the middle of the night. Rang the doorbell, needing to show in a gesture, I'm still in control. You'll hear that in the defendant's phone, when law enforcement apprehend him, in his phone, they find a screenshot that has a section of the registration of Rosalio Gutierrez on it. It has the signature section for the person who is Rosalio Gutierrez's stepfather. And in handwriting, which the daughter will tell you is my father's handwriting, it has Rosalio Gutierrez's home Kenosha address written down. Now, the event I've told you about on April 24th occurs at Sadie's home. The defendant, of course, knows Sadie's home, right? He's been there in the context of the children, etc. This is new. This is information about Rosalio Gutierrez's home. You'll hear Sadie Beecham indicate that also during this time period in April, she finds Olivia to have a phone she didn't know that she had. She looks in the phone. She discovers and knows that it's the defendant, one of the multiple phones the defendant utilizes. And you'll hear Both Sadie and Olivia describe multiple phones. The defendant has a phone that he uses primarily, but he has a couple of other phones, one in particular used to record. She's looking at one of those phones, and she sees the defendant has ordered 2 tracking devices from Amazon. They are auto tracking devices you attach to a vehicle, and that are voice-activated recorders as well. So they have dual purpose for spying missions.
This guy's like next level in the spying world.
Spy. So by now, Sadie has heard from her daughter that there was this invasion of her privacy on April 24th. She knows trackers have been purchased by the defendant. She knows through a number of texts how jealous and irrational he is regarding her beginnings of a new relationship. He is describing Rosalío Gutierrez as beaner, booger, using all sorts of abusive names and terminology for him. On May 8th, Sadie again does not have the children with her, and she is going to Rosalío's home. And based on the suspicions of what I've talked about that have occurred in the last couple weeks, she thinks to herself at some point, you know what? He's probably tracking me. And so she searches her car, and she finds hidden under the car seat of one of the twins a phone that she knows belongs to the defendant, and it's on, meaning it would track her location. On May 8th, she drives to Kenosha. She turns that phone off. There's then a controversy between her and the defendant where he says, well, I just lost that phone. That phone must have toppled out of my pocket when I was working the car seat for one of the twins. Well, we know from looking at the electronics that he was using that phone and using an app he had just loaded on his phone recently, Find My Phone, to track her that very day. And so the things he told her about the circumstances were simply untrue. Instead, we know it was an app that he was using on that phone, connected to that phone, to figure out just where she would go on May 8th. Every time she brings this up, he acts like she's crazy. He acts like all the facts are false. But when you go into the electronics, when you go into his actual phone or computer, when you talk to Olivia, all the things she suspected and thought are actually true. The defendant is again and again fundamentally dishonest with her, acting as if these are all in her head or are accidents. Let's talk about the continuing escalation that this pattern that I've described shows. On May 13th, Sadie again does not have the children. Again, as a consulting adult, she decides to go down to visit Rosalío at his home address in Kenosha. Now, I want you to understand what we've talked about. April 24th, May 8th, and now May 13th. Because we are talking about just weeks, just days before Rosalío Gutierrez at this same location is never again seen by those who love him, is essentially dead to those who love him. So now May 13th, we're 4 days away from that fateful day. On May 13th, Sadie goes down to Rosalío's. She is going down for food and to watch some movies. On the phone of the defendant, when taken into custody, on that phone, we have in the phone recordings of directions that look like GPS-type directions, which direct you. They are deleted, but they are recovered. We don't have every one of them, but the pattern of them gets you to Rosalío's address. This is the defendant's phone that is traveling per those directions that were deleted to Rosalío's home on the same date Sadie has gone down there. Now, Sadie is in Rosaleo's home. And I want you to picture this, that this is what the evidence will be. Conversations you have as you start your meal and you're sitting down to watch something on TV. Rosaleo says something specific to her about, do you want to watch this or something else? Conversations that many of you have had as you begin to start your meal. Suddenly, right after it comes from the lips of Rosaleo Gutierrez, she receives a text on her phone. The text is from the defendant. And the text is an exact quote of what Rosaleo just said to her.
Yeah, he just completely blew
exact
any
that he's just texted
element
her.
of surprise. Yes, you're
Now,
being
he tells
mocked
her
by-
later, oh, that's an accident. I didn't mean to text you. That was just an accident. But his phone, at that moment in time, is going off a Kenosha tower, not a tower by his home in the Mequon, a Kenosha tower, and it's the tower closest to where Rosaleo Gutierrez lives. So not only do the directions get him there, and by the way, have him arriving at the right time, but his phone places him at that location, quoting what is being said inside.
These dropouts eventually stop, so.
I must be in control. Every gesture has the same pattern. I must be in control.
We are catching up because we missed the first couple days. We're just going to watch the pertinent parts. We're getting up to
By
speed.
the next
we'll
day, May
we'll be watching it
14th,
live here shortly.
we are now
Maybe
literally
not today, but tomorrow.
3 days from Rosaleo Gutierrez being dead to everyone who knows him. May 14th, the defendant now is looking for a confrontation based on his text messages to Sadie. May 14th, 4:13 p.m. You want me to stop by to meet Junior tonight? 4:41 p.m., half hour later. Still not off this topic. So, you're saying I can stop by and meet someone later. Now, none of Sadie's communications are inviting him over, let's make peace, let's talk, why don't you come on over, why don't you two meet? This is the defendant attempting to provoke, but revealing his intentions. This is a communication suggesting I am looking for a confrontation. Here's what Olivia says about the period we've talked about so far. She says, every time I and the twins come over, this is the daughter, I apologize, this is the daughter, age 12. Every time we come over, he leaves and goes to follow mom. Every time we kids come over. She says to law enforcement, I am his spy about mom. I did it to please him. Here's a plan that she describes, age 12, to law enforcement that the defendant has cooked up and convinced her to be ready to implement. A spy operation. You ready? The 12-year-old says, on an occasion where I am brought over, I and the kids are brought to my dad's house because it's a visit, and where I know that my mom is going over to Rosaleo's home, the plan is I will call my dad and pretend, that my dad will drive us kids back to mom's house, which of course would be unoccupied, right? Because Sadie would have gone to Rosaleo's home. So my dad will drive us back to the unoccupied house. It's important I keep a key so that I can get in even though mom's not there. I and the twins will go into the house, and then I will call my dad and tell my dad, even though he's just dropped me off, hey, mom abandoned us and left us alone. This is the 12-year-old telling law enforcement that this is the plan that the defendant devised for her, his spy. And she said, at that point, my dad would report this. He would report that my mom had left us abandoned. That is the lengths that we're willing to go to get control, to end this relationship. They call it the plan. It's discussed multiple times. Now, on May 16th, 2020, one day before Rosalio Gutierrez is never again seen by those who love him. May 16th. Remember, I told you on May 17th how full of hope Sadie was. Well, here's why. On the 16th of May, Sadie gets a communication from Rosalio saying to her, would you like to come meet my kids? Rosalio has a boy 11 and a girl 8. They're at his house for the weekend on the 15th and 16th, and she's being invited for the first time to meet his kids. And they go for ice cream. And I think Sadie will tell you that this is a truly meaningful moment in her life. Still today, when those few hours she spent with those kids and Rosalio. She left for the night. She didn't spend the night. It was the last time she ever saw Rosalio Gutierrez. But it meant something to her because it's not an exclusive relationship, but it felt like her hopes that this relationship was going to build and get bigger and get better and maybe be the relationship for her. It felt like this really mattered. Here's how the defendant was handling that same bit.
Wait for it. Wait for it.
You race down to Kenosha every chance you get to lay down with some Down syndrome Mexican version of your father. That's a text from the defendant to Sadie trying to impose himself in this real moment in her life.
I believe that's the defendant. I believe that's Sadie.
He's texting spy Stephen Lenz, who lives just close enough to Sadie that he can see if cars are in her driveway, Sadie. So he's a good lookout, right? He's a good lookout post. This is the defendant to Stephen Lenz on May 16th, asking if she has a car in her driveway. Remember, she doesn't have the kids. So whether a car's in her driveway or not is frankly none of his business. But his spy is being employed at that moment. So on the 17th of May, that's the day after this big moment where Sadie met his kids. And Sadie has said throughout this case that it feels like the defendant is some way monitoring all her communications. Everything that she's communicating with Rosalio feels like the defendant seems to somehow know it in real time. No one knows how that happened. That's how it is. So at 1:52 p.m., this is literally 8 hours before Rosalio Gutierrez is gone and dead to everyone who knows him. 1:52 p.m., Sadie texts Rosalio. Sadie says to him in the text, I want to be yours and get more serious with our relationship. Okay, that's how she felt after she met his kids. That's her putting herself out there, right? Not an exclusive relationship, but here it is. So there's some text back and forth. Rosalio calls her at 8:30 p.m. that night. This is an hour and a half before he's never seen again. And she misses that call. His last text to her is at 8:36 p.m., his phone to her phone. She never hears from him again. She tries him on the 18th of May. This is a relationship where they are in communication in some way, shape, or form several times a day during this period of time. On the 18th, absolutely no communication from him. On the 19th in the morning, still absolutely no communication from him. And so finally, she jumps in her car and she drives from the Milwaukee area on that morning. What is going on? Trying to figure out what's happening. And she gets to his home in Kenosha. And she finds that the sliding door is open. You'll see in the pictures, Rosalio Gutierrez has that apartment in an apartment complex that's the bottom floor, and his slider and his screen face right onto the road. So the sliding door is open, the screen is closed, and she looks in, and boy, does she see a lot of blood. And she calls 911. And at the moment she calls 911 and law enforcement gets there, there will be a number of things that law enforcement focus on in their investigation. And I'd ask you to think about these areas of focus as you think about the evidence as it comes in this case. One area of focus is, when was Rosalio Gutierrez last alive to those people who know him? The second area of investigation is, who has the motive and who has any pattern of conduct where they would be a person we should look to as a person who might have finished that pattern, completed that pattern, or acted on their motive and ended Rosalio Gutierrez's life. And then the third, of course, area of investigation was, where is the body of Rosalio Gutierrez? And I'm not going to belabor that in this opening. You'll hear about very substantial efforts in many jurisdictions involving many agencies to look for the body of Rosalio Gutierrez, which is never found. So on May 19th, okay, so this is 2 days after Rosalio has last been heard from, at 11:07 a.m., the Kenosha Police Department is at Rosalio's address. And they find through their investigation before too long that the last person in touch with him appears to be a woman whose last name is Macias, who received a text from him at 9:27 p.m. on the 17th, okay? And then she texted him back because she arrived at a building she thought was his. Turns out she was at the wrong building, but she thought she was at his building, and she calls him and texts him multiple times over the next half hour. Where are you? She'd never been here before. Are you coming out? You know, that kind of stuff. And there's never again an answer. So sometime after 9:27 p.m., the state's going to suggest to you all that blood results. And
OMV here, hope you and all in chat had a good weekend.
To those who know him.
Thank you, just Piccadilly fine.
They go through family and friends, and no one has heard from him since that 9:27 p.m. time on May 17th through any other
love the
method
picture.
Of communication.
OMV.
And so law enforcement focuses on Sadie Beecham. Remember, she called 911. She's still at the scene. She is distraught. She's shaking. She's overcome. And she's really focused. Members of the jury, you'll hear the officer testify. She's really focused on getting her kids safe. She's afraid that the defendant has done this and that her kids might not be safe because of what she sees. And so she is allowed to prioritize that, and then this investigation, of course, continues. Rosalio's vehicles are still at the residence. His keys are there. There is a large amount of blood all over his residence in several rooms. The outer hallway, including outer hallway in a way, suggests that door opening into the hallway was open at a time when significant bleeding happened, including sprayed blood that looks like it's impact type of blood. There's blood then right inside the door, as if someone is now in the apartment and they are continuing to have some sort of intervention or attack happen where their blood is spraying. That blood is all over that now closed door on that interior. It is all over the rug area there and on the walls and on the tables. It extends to the dining room table. It extends to the chairs on the dining room table. Some of it hits the laptop. Some of it is in the kitchen counter. Some of it is pooled blood throughout that area where you are first in the entrance. There is a small stick of processed wood, like a baseball bat or some other hard object. It's not a log. It's not a piece of cut timber. That piece of wood ends up having blood on it, which is found to be the blood of Rosalio Gutierrez, and hair on it as well, which is also found to be Rosalio Gutierrez. There is significant blood on the curtains, which are on the entire other end of the apartment from where that entrance to the hallway comes.
He just keeps getting louder.
There is blood on the fan.
Down.
There's blood on the ceiling in multiple rooms of this apartment. There is pooled and seeped blood into the carpet in the living room on the floor area, and seeped blood, a significant quantity of seeped blood on the couch that is the primary couch in that living room. And in the middle of the area by the couch, there is a missing area where there's blood surrounding it, but then there's a rectangled off area that has no blood whatsoever. It's pristine, which certainly suggests to anybody who looks at it that an area rug, a medium sort of size area rug, was there when significant bleeding happened and is now missing from that apartment. There are little splinters of wood on the couch that are also there, interspersed in the blood and interspersed in hair that is located, strands of hair located on that couch as well. Law enforcement tests several locations at various places. You'll hear where they tested. Each time they tested and they found that it was blood, each of those times the blood came from one individual, and that was Rosalio Gutierrez. You will hear that the blood is sprayed, meaning there was impact in multiple locations and multiple different times based on where the blood is located and how the blood presents or looks when law enforcement is present. Remember, present 2 days, about a day and a half after the event. Again, that area rug is completely missing. You'll hear that you might hear some testimony about something called arterial spray, where there's a finer, misty place there too. So some of what you might hear is blunt force trauma, hard objects hitting a bleeding surface. Some areas that you might hear about are more likely, or at least are possible areas where maybe a knife or some sharp object penetrated someone as opposed to blunt force.
So it's the boyfriend who is missing.
Rosalio's own phone records say that he dropped his kids off because he had them that weekend. He dropped them off on the 17th. And then he went home, and he was home by 9:08 p.m. So just within an hour of when he's never seen again. Opened a beer, drank a beer. I think maybe opened a second beer. Was expecting this Miss Macias to arrive. His TV was on, and his phone it goes off at 10:30 p.m. around, and that's found several days later, hidden in in his freezer. His phone and his credit cards are behind all the items in his freezer, hidden there. In the cold, the phone goes off. The last time that phone is on in any way, shape, or form is around 10:30 p.m. on the 17th. Rosalio's keys are there. His wallet has ended up on the couch over some areas that already had blood, so it was placed there after the bleeding occurred. As I said, his credit cards were found in the apartment. There's been no evidence that his credit cards or his bank accounts or any other identifying pieces of that type have been used ever in the 1,018 days.
I believe we're going to see some crime scene pictures, and some may have blood in them.
The home, you'll see the pictures, is
Just
filled
FYI.
with pictures of his two children, 11 and 8. He didn't miss gymnastic events.
I'm going to get it wrong.
He was an enthusiastic baseball coach for his 11-year-old. You will hear electronic media talk about his excitement and planning for his coaching of his 11-year-old that will be starting literally just days, certainly weeks. Baseball season is right around the corner, and watching his son play baseball was one of the true pleasures of his life.
Joan, we're catching up on the opening statements because we missed them.
2 days after he is gone, he has in his date book, his planner, that he is going to be at Camp Timberlea with his children. Some of you may know that local summer camp. That's a 2-day. That's an experience that's supposed to occur on May 19th, just 2 days after this. He never arrives. He never accounts for this with his kids. Obviously, he never coaches baseball. In fact, neither of his kids, who talked to him all the time, who saw him every week, who were in contact with him multiple times a week. You'll hear that his 11-year-old son spoke to him during this time period multiple times per day. And there was never another split second of communication, and has not been for 1,018 days. He has missed their birthdays. He and his mother had a very close relationship. Very close. And he has missed all of her important occasions in the last 1,018 days. And the kids he was so devoted for. Never, ever before missed these occasions. Never before, ever out of touch his entire life with the people who cared about him. And not a peep from him since. So I'm back to who the police should go to first. The defendant has actively admitted to Sadie that he is jealous, that he has admitted to...
He's looking at Sadie when he looks over there.
He has admitted to Sadie, and then finally to law enforcement, that he took his 11-year-old, as I mentioned, to the mom's home. He has a recording of that incident in his phone, a brief recording of that in his phone. And so law enforcement certainly focuses on the person who has documented motive and jealousy documented. All of this is interesting because it happens while the defendant, according to a woman, his girlfriend, Christine Remsburg, is literally living or staying 4 or 5 nights a week at his girlfriend's home. So what I'm describing to you are things he is doing only when he has his kids over, if he is actually traveling around, or he is doing it despite the fact he continues to have this relationship with, when she's interviewed in May of 2020, she says this relationship has been going on about a year, and that he spends 4 to 5 nights a week at her house. But the motive for the defendant is to end this relationship and to do anything he must to stay in control. So, the defendant has his kids on this weekend of May 16th and 17th, right? This is the fateful weekend. Sadie picks those kids up in the afternoon. So in the late afternoon, she picks those kids up. And the daughter will tell you, 12 years old, the back of my dad's van, his minivan, which he used to transport us on the afternoon of the 17th, so the same day this happens, was normal. There were no bleach stains and no problems with the carpet in the back of his minivan when she last saw it on the afternoon of the 17th. So now the question is, what is the evidence that the defendant prepared for this attack, this murder? Well, one of the things he did was on May 15th, he took out $50,000 in cash from his account.
Sounds normal.
When law enforcement gets there, he still has more than $46,000 in cash. You're going to see pictures of the bank bag, literally all the money still bound together. So he's got that, and the state will suggest to you that's in case anything goes wrong. He can make that
Judge
quick
just got a
run
refill
to some location to be out of harm's way or out of apprehension with that much money on hand. You'll hear the daughter indicate that when she left on Sunday afternoon, just hours before Rosalio Gutierrez is gone, that she saw rope and duct tape, new rope and new duct tape, down in his basement. It was down on top of essentially a wheelie, a desk chair that's down there. When law enforcement gets to this location on the 19th, there is a wheelie chair down there in the basement. The daughter is completely right about that. But no rope, no new rope, and no new duct tape. So the state would suggest to you that is ideal stuff if you think you need to move a person bleeding, dead, if you need to seal up a carpet, try to prevent as much bleeding as you possibly can from the body of the person you're removing from his own apartment. During this period of time, there is an extremely heavy rain going on in Kenosha and in the Milwaukee area. Very heavy rain.
Carol, that's a really funny typo.
And so people are not out and about, obviously, in the same way they normally
not everyone
would
can
be.
just go get 50
Another
grand
way
out of the
that
bank.
the defendant prepares is when we go into his multiple phones, we find that the phone he usually uses to contact people, the phone that he usually uses in situations, is not being answered, though it is just before and just after, but not being answered from 7:30 p.m. to 11:19 p.m. Left behind the phone that had smart capabilities that would be tracked, left that behind, and so was not able to answer the calls and the texts that come from multiple people, including his girlfriend, Christine Remsburg, who tries to contact him multiple times because she is expecting him in those evening hours to come over. She's talking about what they're going to have for dinner. She's talking about what movie they're going to watch. And finally, she basically, sometime before 11:19 p.m., says, okay, I'm going to bed. She's expected him. And he never shows up at her house and never gives her an explanation until after he would have time to drive from his home in Mequon to Kenosha, commit this crime, and get back to the Mequon area, grab up the phone that he hasn't been answering, and now texts her and says, oh, sorry, fell asleep. Fell asleep during the exact hours that Rosalio Gutierrez is never seen again. And then has a very long conversation with her, like a 42-minute conversation with her from midnight to 12:49, maybe trying to get back in her good graces. Because she's back with him the next night. She comes to his house for one of the very first times she's ever come to his house. She comes to his house that night, the next night, and then the night after that, which is the night he's apprehended. So then I want to talk about the cover-up. Because a lot of times the way you can tell that somebody's responsible for something is their cover-up, right? That's a common way of determining somebody did something really bad. So officers get to the defendant in the evening hours. And so it's been 2 full days since Rosalio Gutierrez is gone to everyone who knows him. And prior to police getting there, a close couple of buddies of Rosalio Gutierrez who have heard Rosalio Gutierrez say, hey, I've got this new woman I'm seeing, her name is Sadie, she's got a crazy ex-boyfriend, and maybe even that he broke in my truck one time, right? So when Rosalio Gutierrez is missing, and the friend group begins to understand this, Michael Campbell is the type of friend who will drive to the person's house where that is suspected in his mind and just go and try to confront the guy. And so he and his buddy go there.
What could go wrong?
And they beat the police there because the police are still, doing the police things. And they bring up, hey, our buddy Rosalio is missing. Do you know anything about this? And the defendant claims he's not his brother, claims he's not Zachariah Anderson. He claims he's his brother. He calls the cops. By then, these guys have already left. They're not trying to fight anybody or anything else. They're simply trying to ask a question. This guy's clearly not going to answer their question. They leave. So he already knows by that moment that Rosalio Gutierrez, this person he's focused on, who he's been to his house, he's texted a direct quote of what he said, he's done all sorts of other stuff regarding him, he's certainly communicated to Sadie many times about him. This guy's missing. When they go on the 19th and they look inside that minivan of the defendants, they find that the back is bleached. There's all sorts of bleach stains on the back carpeting. That the seats are out, just the front seats are in, and the back third of the carpeting in that van has literally been cut out. So you're down to where the electronics is exposed, you're down to the plastic flooring under.
Sounds normal.
The carpeting from the minivan is missing, is cut out.
I thought he was guilty as soon as he said he drove a minivan.
Where
this guy, man bun and
on
minivan.
The 17th in the afternoon,
that's not a good look.
His daughter said, yeah, it was in there. Nothing was cut out of there. And there was no bleach. Fresh smell of bleach. Carpet cut out in the last 48 hours. You'll hear that in the early morning hours on the 18th, so let's say defendant arrives back in Mequon. By 4:18 a.m., he's searching for area stores by him and when they first opened. So he puts in Menards, he puts in Walmart, he's going through all the basic stores. Which of them opens first is essentially his line of inquiry. And he ends up getting a Walmart, opens at 8. This search happened at 4:18 a.m. Okay, this is now about 6 hours after Rosalio Gutierrez is last known alive. And you will decide what to make of this. The defendant arrives there just after 8, like 8:15, 8:18. It's pouring rain. It's still pouring rain, just as it was the day before. Pouring rain parking lot, not many cars. He parks as far as you can humanly park that minivan from the entrance.
He just wants the exercise.
And he walks that whole
sounds
distance
normal as well.
in, as
Trying to get his
opposed
steps
parking
in, right, Ivan?
in any of the probably hundreds of spots that are closer.
Okay, he's got about 15 minutes left on his opening
possible.
statements. He's almost done. Then we're going to skip ahead a little bit.
Does he have the body still in the back of that car, wrapped in that rug? He buys, with cash, bleach, rubber gloves, garbage bags, shampoo, Q-tips, pays cash, leaves, and heads over to an area where he is doing home demo and he's doing some demo at a lake house in the Belgium, Wisconsin area. A little more isolated locations, not his house.
They're all kept out of the same aisle,
in case
just for
law
convenience
enforcement
there.
was already looking for him, in case the body had been discovered. This is on the 18th in the morning. Okay, just hours after Rosalio Gutierrez has never been seen. He's at that location, according to his phone, for 3 hours. And then leaves, goes to many other locations, but near that location, so within that immediate area, is a state park, is Lake Michigan, is a number of other remote locations, and hundreds of dumpsters, right? Over the course of any area in Wisconsin, there are hundreds of dumpsters where you might put the remains of Rosalio Gutierrez. He's got a burn pit at his house that he has smoldering when the cops get there 2 days later. He's been operating the burn pit in the pouring rain. In it are an underwear band from Fruit of the Loom underwear, jean buttons, steel-toed boot components. Did he burn some clothes that he might have been wearing on that day?
Thank you, Lost Souls Paranormal. Gifted a membership, and it went to Last Poet.
Officers eventually get into the defendant's laptop. When they get into it, they find a file that's labeled Rosalio Gutierrez Jr. So it's got his name. This is before law enforcement talks to him. I mean, you know, I'm sorry, they don't know this. They haven't been in his computer when they speak to him. But he's typed in the name, Rosalio Gutierrez Jr. In that are picture after picture screenshots of Facebook photos of Rosalio Gutierrez out socializing, but also a number of pictures of him with his kids. And we're going to show those to you to let you think about whether this is obsessive sign of dangerous behavior, to have collected these kind of photos in this folder on your laptop. It's got business info, it's got CCAP entries, it's got an electronic map that's pinned to the actual location of Rosalio's home. And then in that same file, under that same label, he's got a picture of one of these trackers. Just a photo of the tracker, you know, like a screenshot, right? Auto tracker, voice activated, that spy equipment that he has ordered and paid for just days before. So the defendant, when law enforcement speaks to him on May 19th,
I think he's going with the "it wasn't me"
knows
defense.
Rosalio Gutierrez is missing, knows they want to talk to him about the possible stalking of Rosalio Gutierrez. That's what they tell him they're talking about. He knows what he has been doing. He knows the facts that we've described happened. There's no way the defendant does not understand how important a moment this is. Here's his chance, if he's an innocent man, right, to talk about exactly what the details are that will exonerate him. Let's clear this up. Here's what the defendant does. When asked what vehicle he drives, he wants to stick with that he drives the Audi vehicle. In actual fact, Christine Remsburg is driving the defendant's Audi around because her car's on the fritz.
I always thought it was like an Audi.
So he hasn't driven that car around recently much at all. In the Walmart video, for instance, on the 18th, he's driving the minivan. When he drives the kids back and forth on the 17th, he's driving the minivan. He decides to only share that he's driving the Audi. Why not bring up the minivan? Why not tell him right away, hey, the car I'm using is the minivan. Please go search it. Go do whatever you want. Go take a look at my minivan. Absolutely. Instead, he wants to talk about the Audi. Reluctantly indicates that the minivan is a vehicle. Oh, but you know, anybody could drive that. That's how he decides to behave, knowing how important this moment is. He acts to these officers, tries to give these officers the officers the impression he doesn't even know this Mexican guy's name. I think they call him Junior, something like that, he wants to say. Well, he's written Rosalio Gutierrez Jr. in his computer. He's told his daughter the name of Rosalio Gutierrez. There's a phone message or a phone recording that he records between him and Sadie where he finally admits, okay, I told her the name. And yet with law enforcement on the 19th, he chooses to act as if this is not even a name he knows. He says Olivia gets that from a grandma, when in fact, he admits to Sadie that's not the case. He denies ever being at Rosalio's home to the officers, where we know based on the electronic evidence, both his text and his own phone, that he's there on May 13th. We know that. But he chooses to deny that he has been there. In fact, says, I don't think I've been to Kenosha. Though his phone is going off at Kenosha Tower when he is directly quoting Rosalio. Then, he's asked a very simple question. Again, this is the 19th. Where were you in the evening 2 days earlier? Okay? Not where were you 5 Wednesdays ago. Where were you in the evening 2 days ago? He says, yeah, I was with my girlfriend, Christine Remsburg, spent the night over there, that's where I was. Later goes off that, later changes that up a little bit, but that's what he wants to go with. When Christine Remsburg, who has been with him the last 2 nights after he didn't show up at her house on the date of this homicide, when she's asked that question, also during this exact same time period, where was he? She also chooses to provide false information about his whereabouts. She says, yeah, he was with me, and that's completely false. She eventually is exposed because her sister says, that's not what happened, and when confronted with that, she says, okay, you're right. He wasn't at my house. So the two of them have exactly the same false information about where he was.
That's sometimes called an alibi.
You are going to finally hear 2 other important pieces of evidence from the state's perspective. One is when the crime lab examines the van in question. These are people who are the experts in the state at trying to figure out whether there's worthwhile evidence and then trying to do the appropriate testing of evidence having to do with DNA in the state. And so the experts come and the van is eventually brought to them, and they go through that van and they identify a particular location that is near the back, so in that same 1/3 of the minivan where the carpet has now been cut out, but it's about halfway up and it's on the plastic panel and it's just a little speck.
Just a speck.
And when the 2 DNA and crime scene analysts, when the DNA and crime scene analysts see that, they both say, we think that's blood. But it's so small that they decide that is just going to be our observation. We're not going to use a chemical on it. We're afraid we might not get DNA if we do that. So they observe, they believe it's blood. It is taken to the crime lab. It is tested. And based on the results, again, the analyst, Lisa Treffinger, will tell you she believes it's blood. She believes that based on the process of elimination. It's not semen. It's not skin cells. It's not saliva. It's not a piece of hair. And therefore, based on the content, based on what we can get on the results, it is blood. I believe it to be blood. She'll offer that opinion to you. She'll also tell you that her test tells her that blood is the DNA of Rosalio Gutierrez. Rosalio Gutierrez, there's not going to be any evidence he's ever been in this van, certainly that he's ever bled in this van, that he has anything to do with this van, and his blood, his DNA, is located on that speck amidst the area, not in the same area, but in the van filled with bleach and with the cutout carpet. Cutout carpet is never found, by the way. Clothes that the defendant was wearing on the 17th are never found, by the way. Then finally, you're going to hear evidence of an individual, an inmate named Marquand Washington. Marquand Washington has very serious federal charges that are going on right now, and he's being
keeps skipping. Sorry.
You'll hear him say that several months ago, he came forward to his attorney and told his attorney that I previously roomed with I shared a cell. I was a bunkmate with.
You should have burnt the van too.
That when that occurred, that we bonded over some common sort of criminal activity. So, we talked, and I'm not going to talk about the details, but that they bonded over some discussions of their life prior to this date. You'll hear that Marquand Washington was able to tell details about the case, such as when the police raided residence, they found a lot of money and a little bit of weed. And that you'll hear Marquand Washington say the defendant described the house that was raided as a crappy house, but in a nice area.
A crappy house in a nice area.
You'll hear Marquand Washington say the defendant told him when talking about murder that murder takes a lot of work, that you have to figure out ways to track people and stalk them, learn their habits, learn what they are up to so that you can find your moment.
This guy was a pro.
He suggested trackers from Amazon would be something that would be worthwhile to consider. Marquand Washington says the defendant told him that he wrapped the body up and took it away, that he put the body in trash bags, that he made sure the trash was gone and so it will never be found. Marquand Washington will say, well, how did you lift that guy? How did you lift him, however you got him out of there? And the defendant told him, I was working out at that point. I was so strong, adrenaline. He said, I was like Superman. The combination of adrenaline and my working out was what allowed him to do it solo. Marquand Washington tried to get him to tell him, well, why? Why'd you do this? And he said he never really had a real answer, but that one thing that struck him that the defendant told him was, my ex was getting serious with this guy, and she was happy.
If you guys want, we can speed this up a little bit. We can take it up to like 1.25 or something. He's almost done. He's got about 6-7 minutes
to Marquand Washington. He also had a
testimony.
girlfriend then, though they are no longer together during the period of time that the two of them stayed together. But he provided those details.
4 minutes more.
So you'll hear about
and the video keeps
the act
kicking
itself.
the cable or something.
You'll hear from people who love and care about Rosalio Gutierrez that he is gone. You'll hear about the physical evidence, and you'll hear about the confession made. And when you combine all of those pieces of evidence, then from the state's perspective, you will have enough evidence and will hold the defendant responsible.
Okay.
Thank you.
So there's the state side. The defense is going to go, and this is going to be interesting because
break.
we're going to skip past the
I
break.
indicated when we broke yesterday, I had some further discussion with the lawyers about some legal issues, and then I was doing some more reading last night, and have come to a decision. I've given them the decision, but I'm going to give them the explanation. So that's going to take a little more time than the usual break. I'm hoping we'll get back together in about a half an hour. Please don't talk about the case during the break. And as you know, there are 21, I think, 21 steps to the jury room. If that's something
those
that,
are steps up, not steps over.
Problem. Just tell the bailiffs, and they'll give you directions how to get up without using the steps. Any questions?
That would be called an elevator.
Okay, we'll see you.
Or maybe there's a dumb waiter. You have to climb in and somebody wheels you up. But these jurors, their legs are just going to be ripped by the end of this case because every time they go out, they have to go upstairs and back downstairs. So, okay, we're going to skip ahead just a little bit because there's a little bit of a break. So I'm headed to, let's see, we're at 21:13 right now. We're going to 21:34:40. Okay, so here's the start of the defense. The break's over, jury's back, and this is the defense opening statement.
Don't have as loud of a voice as the state, so have to use the mic.
They're going to fix the mic here as well.
The essence of this case is actually quite simple. The state just walked you through for quite some time about the evidence and how it thinks it's going to come through during this trial. But at the end of the day, law enforcement nor the state have no idea what happened to Mr. Gutierrez's body. They don't know when exactly anything happened in Mr. Gutierrez's apartment. They have no idea where any alleged remains of Mr. Gutierrez's body is. They have none of that. There are no witnesses that saw my client, Mr. Zachariah Anderson, at 3709 15th Avenue in Kenosha on May 17th, 2020. They have absolutely no witnesses that say, hey, we saw Mr. Anderson and he had bloody clothes or he was acting suspicious. They have none of that because none of that evidence exists. No body, no human remains, no indication of cleaning up a crime scene despite what they state occurred in that van. I'll talk to you a little about that later.
I'm going to try.
They don't have any of that. Yet they decided to build a script, and the evidence will show you this. They decided to build a script and tell a story and make Mr. Anderson the main character, despite the fact that they didn't have any of this evidence. No body, no human remains, no witnesses, nothing. If you're looking in the wrong places and at the wrong people, you are not going to find the information you're looking for. The state just talked to you at length about some of the evidence that it believes is going to come in, and that evidence is going to show you that Mr. Anderson committed the crimes as charged. And the state and myself, he explained to you kind of what opening statements are. I'm not going to do that. You're all capable people of understanding why we're speaking to you right now. But I'm speaking because I see the evidence a little bit differently. And when I'm walking you through the evidence that will come in today, it's not based on speculation. It's not based on some theories that are in my head where there's no evidence to back that up. I'm going to walk you through the actual evidence that will come through during this trial. But let's start with what the state kind of walked you through. That this really all stems because Mr. Anderson is a crazy, jealous, obsessive ex. The evidence during this trial will debunk that theory. And in addition to that
the first one was a mistrial.
Motive is not an element of the crime. In order to be threatened by a serious relationship has to exist. The state talked about how things were getting heavy between Mr. Gutierrez and Ms. Beecham, that they were meeting each other's kids, that there was talk about that. What the state didn't inform you was that Mr. Gutierrez was actively dating and seeing several other women. He was not in any means exclusive with Ms. Beecham. He had in fact told some of his closest friends that he was intending on breaking up with Ms. Beecham. Ms. Beecham had never met a single one of Mr. Gutierrez's friends. And this concept of that the state talked about how, she had never talked to her child about Mr. Gutierrez, or that information must have come from Mr. Anderson. That's not accurate. And the text messages that will come in will establish that Ms. Beecham had discussed Mr. Gutierrez with her daughter. There were text messages that she sent to Mr. Gutierrez that says, Liv wants to meet your kids before she meets you. Well, obviously she must have had a conversation with her daughter about who Mr. Gutierrez was, but still doesn't change the underlying factor that this was not a serious relationship. Additionally, from February of 2020 through May of 2020, there was consistent communication between Mr. Anderson and Miss Beecham. And that communication wasn't, oh, I want you so bad, come back with me. It was kind of a mutual agreement that their relationship was toxic. They were never getting back together, that she had guys she was seeing, and Mr. Anderson had his own girlfriend.
Thanks, Kathy, for the 5 gifted memberships. Michelle, Giovanna.
The timeline. The state said that the timeline shows Mr. Anderson must have been involved, but the state's ignoring critical evidence as to that timeline. The state admitted May 17th, 2020, Mr. Anderson had his kids, his 3 children. They were at his home in Mequon, Wisconsin. That later in that afternoon, around 5 to 6, Miss Beecham picks them up. Mr. Anderson then, they don't have any evidence that Mr. Anderson left his home. They claim that this is the time where he traveled down to Kenosha, but you'll hear from law enforcement officers that they got surveillance video from multiple places, not only in the Mequon, Ozaukee County area that Mr. Anderson would have had to pass to get to Mr. Gutierrez's apartment, but they also got surveillance from gas stations, schools, the transit authority, from the buses, from neighbors' ring cameras, from the area in Kenosha that Mr. Anderson would have had to have passed if he was driving. And you'll hear from law enforcement that they don't observe Mr. Anderson's vehicle.
He's in jail, Chris.
So the state has absolutely, there will be no evidence during this trial that will be presented to you that shows that on May 17th, 2020, when Sadie Beecham is at Mr. Anderson's home, she sees him there. He then texts someone at 11:19 p.m., and you'll hear from law enforcement officers that his phone pings at his home at 11:19 p.m. Nothing shows he ever left home that night. People falling asleep around 7 to 8 p.m. as adults who have children and have been with them all day, that's not unreasonable. So the next morning, he wakes up, he goes to Walmart. You'll hear evidence that Mr. Anderson's a contractor. He was going to a home up in Cedar Grove area that he was working on. He was doing lath removal and other serious removal jobs. It was basically a complete reconstruction of the property. And so if he went to Walmart and parked far away, you'll hear evidence that he likely had tools in his van. And in addition to that, he then goes to his job site for 3 hours. And the state's saying that after that, they don't know where he goes. No idea. The evidence will establish that after he was at the house in Cedar Grove for 3 hours, he went to Menominee Falls to pick up his taxes. That's a nice fact that the state didn't talk about that will come in. And what's interesting about the fact that Mr. Anderson had gone and picked up his taxes in Menominee Falls right after working at his job site in the morning is that that evidence wasn't readily given to the defense. That you'll hear that this evidence, this receipt that stated 5/18/2020 from the tax accountant services was a piece of paper that was located in Mr. Anderson's van. And that law enforcement, when they executed the search on Mr. Anderson's property, they took all the papers and put them in a pile and labeled them miscellaneous papers. And they took one picture of all of those papers.
She just murdered
and
that
put
word.
that into discovery, and that picture's blurry. You'll see that picture.
Miscellaneous.
It wasn't until the defense asked to see that documentation that we saw this receipt that proved that Mr. Anderson wasn't, for hours, getting rid of a body, but was going to pick up his taxes in Menominee Falls. And you'll hear from the accountants that he was there. You'll also hear from them that they had video surveillance, that law enforcement, had they gone and talked to these people, would have been able to get that surveillance video to see what Mr. Anderson was wearing, the fact that he didn't have any blood on his clothes. And then after he picks up his taxes, he goes back home and spends the night with his girlfriend, Christine Remsburg. The next morning, they wake up. It's a normal day. But it's not normal for Mr. Anderson because 2 random people show up on his property demanding that they speak with a person named Zachariah Anderson. And Mr. Anderson knows that he doesn't know these people. They don't know what he looks like. So he says, hey, I'm his brother. He's not here right now. What do you want? And they say, as the state noted, we're looking for our missing friend from Kenosha. And these people are snooping around his property, acting suspicious. And so what does Mr. Anderson do? He calls 911 himself and says, hey, there's these 2 random people that are on my property demanding to speak with me. I told them that I'm my brother because I'm a little concerned about why they're here, and they're demanding questions about their missing friend from Kenosha. The man who the state's alleging had something to do with the disappearance of Mr. Gutierrez is calling 911 and saying they're saying that I had something to do with this missing guy from Kenosha. Law enforcement responds to the home, but it's not to respond to Mr. Anderson's concerns. They're there to arrest Mr. Anderson and to execute a search warrant on his property. He's taken into custody. They take pictures of what he's wearing: white t-shirt, blue jeans. They send some of those, they say, oh, there looks to appear to be a stain on this shirt. Let's swab it and send it to the crime lab, not blood. No DNA of Mr. Gutierrez. Oh, the jeans. Looks like there's another red dot. Let's swab it and send it to the crime lab. No blood, no DNA linking back to Rosalio Gutierrez. They took pictures. You'll see these of Mr. Anderson's hands, feet, arms. Not a single scratch, not a single bruise, nothing. So the state's assertion that there's going to be evidence that Mr. Anderson had time to get rid of every single possible piece of evidence, the body, all remains, everything that he used to clean up. The state talked about some items bought at Walmart. They were 13-gallon trash bags and 2 things of Clorox wipes. Don't think that's enough to meticulously clean up a crime scene, nor is there any evidence that that is. Additionally, as you'll hear, this was during the height of COVID. It was basically still almost about to be the lockdown.
Like regular daily usage stuff.
Actually, was in the middle of the lockdown. So searching to see what stores are open before you go to a job site was not bizarre. You'll also hear that during COVID, items such as Clorox wipes and gloves were extremely hard to come by, and you would pick them up when you got the opportunity. So the timeline that the state told you, there's evidence that supplements that shows Mr. Anderson could not have had the opportunity to commit the charged offense. The other piece of evidence that the state talked about was Marquand Washington, and that Mr. Anderson allegedly admitted to him that he did this and that he stabbed Mr. Gutierrez, took his body, put it in some trash bags, and took the trash out and got rid of him forever.
Maisla, congratulations.
The state talked to you a little bit about Marquand Washington.
Thank you for your support.
Marquand Washington is currently facing a minimum of 10 years to life. And it's a federal case. And you'll hear during this trial that in federal cases, when there are mandatory minimums, the only way to deviate from that mandatory minimum, so the only way to get less than 10 years is if you cooperate. If you provide information and then get on the stand and testify to that and cooperate, that the government, who's the prosecutor in a federal case, can file a document to say, Judge, we're asking for lesser than that 10-year mandatory minimum. And you'll see that in Mr. Washington's plea paperwork, the government nicely outlines that in order for you to get less time, this is what you're going to have to do. Now, the state didn't mention this to you, but Mr. Washington is someone who will literally do anything to get out of his situation. That they had evidence, that the federal government had evidence that he intimidated the witnesses and victims in his own case in an attempt to get out of his situation. And when that didn't work, he was left with one option: cooperation. And in February of 2022, the federal government was told that he had information that he wanted to share. And they wrote a letter to him and they said, Mr. Washington, we've heard that you want to share some information about some crimes that you have knowledge about in the Milwaukee surrounding area. Please let us know what that is. He did not mention Mr. Anderson in February of 2022, and that's critical because the state said that Mr. Anderson trusts Marquand Washington, but Marquand Washington only was housed with Mr. Anderson for approximately 3 weeks. It was a very short housing situation, and those 3 weeks was from February of 2022. Or no, sorry, I apologize. It was December of 2021 to January 31st of 2022. So in February of 22, he would have had this information, but he didn't share it then. No, he only shared it about 3 weeks.
Okay, this lawyer's going to keep going.
In a case that's been going
here
on since May of 2020, when he's allegedly had this information for almost 2 years.
But she only talks
so
about
what's even
half
more
an hour.
Critical is Marquand Washington,
1.25 speed,
as
so
the state says, he will testify, and I'm saying as the state will say he will testify because the defense did not have the opportunity to meet with Mr. Washington. Mr. Gravely, the district attorney, and Vincent Carrera, a detective, they met with Marquand Washington, and they questioned him for an hour and 30 minutes approximately. They did not record the interview.
Lee, you're right.
Instead, they
We've
gave
got
the
less than
defense
10
a
minutes
2.5
before this all
summary
falls apart.
of what he would say.
The train goes off the tracks in just less than 10 minutes.
But what I do know from that 2.5-page summary is that he claims that Mr. Anderson said he stabbed the guy. The state talked about how you'll hear from officers about the blood stain pattern analysis completed in this case. That officer will tell you that he believed that the stain patterns that were seen in Mr. Gutierrez's apartment were consistent with blunt force trauma. That was his opinion just in February of last year, Officer Van Wee, and in his reports from closer to May 2020, he wrote that he believed it was blunt force trauma, so a heavy object or an object hitting someone. And also, Detective Carrera wrote in his reports that it was blunt force trauma. There was never a single mention in Van Wee's reports or Detective Carrera's reports that the stain pattern analysis were consistent with sharp force injuries. There's a difference between blunt force injuries and sharp force injuries. Sharp force injuries is a knife. No mention of that. In fact, you'll hear that Mr. Gutierrez was an avid baseball fan, loved baseball. Not only did he love baseball, but he loved to play baseball with his kids. And he was a coach for minor leagues. And so he had baseballs in his apartment and in his truck. He had gloves in his apartment and in his truck. You know what wasn't recovered?
Bleach.
In the crime scene?
What?
Or in a truck? Not a single baseball bat. Not a single one. But the state told you that they had a shard of, the state said it themselves, what could have come off of a baseball bat with blood on it. So the evidence will contradict itself. It can't be the stabbing and it can't be the baseball bat. The next item that the state talked about was the DNA in the van, and the state claims that there will be a witness that will get up here and tell you that that was blood in that van. And I'm not sure where that's coming from. Because Lisa Treffinger, who's an analyst at the state crime lab, was the individual in charge of processing the van and that particular dot. And it was so small, like freckle size. She's the individual responsible.
Can't believe you missed
You'll
it.
hear from her and other state crime lab analysts that they processed that van extremely thoroughly. You'll see pictures of the van too. Not a van that's been cleaned. There's dirt everywhere, dust on the dashboard, no indication that it's been cleaned, no blood in the front driver's seat. In fact, no blood anywhere. They saw red dots, tested it for blood. They did a test that's specific to determine if a item that purports to look like blood is blood. Negative. They did luminol testing. I don't know if any of you are aware of that, but what they do is they spray this substance and it will basically light up if there's the presence of blood. Didn't light up. They said that there was this one flicker of light, so they tested that area. Negative for blood. This dot that the state claims someone's going to tell you was blood, in an email from Lisa Treffinger, the analyst that will testify, you'll hear her tell you that the state asked her. An email from the state. I just wanted to confirm that the sample that was sourced to Rosalio from the van was blood, right? This was analyst Treffinger's response, and she'll testify to this. We could not confirm it was blood. Her own words, not mine.
Okay, it's got about 6
DNA
minutes
in
that
his
goes
van,
off the rails
How do you
here.
explain that? The state claims that the explanation of how Mr. Gutierrez's blood got in the van was because Mr. Anderson must have killed him. But the evidence will tell you that there's a far more logical explanation for how that occurred. The state talked to you about the evidence that might come in about an incident that happened on April 24th, 2020, where Mr. Anderson had gone into Mr. Gutierrez's vehicle, had taken something out. This was talked about between Ms. Beecham and Mr. Gutierrez at length. Ms. Beecham told Mr. Gutierrez on April 25th about what had happened, how Mr. Anderson had gone in his car. And they talked about how maybe something should be done about that. There was conversations between them about how maybe Mr. Anderson should get a taste of his own medicine. Later that night, at 11:10 p.m. on April 25th, 2020, Ms. Beecham received a text from Mr. Gutierrez that said, "What's his fucking address?"
Beep.
Sadie responded, "Well, I guess if he has your info, you should have his." And then
The jury is allowed to take notes in this trial. They've been
Mr.
encouraged to.
Gutierrez sends her a text with Mr. Anderson's address. This is on the 25th. And then on the 26th, he sends her a text that says, "For the record, only if you say it's okay." He also sent, and then Ms. Beecham sends him a text, "He's going to find out." This all happens on the 26th of April. Mr. Gutierrez is apprised of the fact that Mr. Anderson went into his vehicle. Sadie and Mr. Gutierrez talk about how something should be done similar to Mr. Anderson. And then, on April 26th, 2020, Mr. Gutierrez's Cellbrite location data puts him at 6813 Highland Road, Mequon, Wisconsin. He's there. Mr. Gutierrez, after talking about how something similar should be done to Mr. Anderson, that something similar being going into a vehicle, is at Mr. Anderson's house. His location puts him there. And then right after he's there, he has a video FaceTime with Miss Beecham for 2.5 hours. And that conversation occurs at 3:11 a.m. in the morning.
I believe he's been in jail the whole time. That's my understanding.
In addition to the fact that there's more reasonable explanations, as you'll see through the evidence, that is ignored by the prosecution, the fact that the timeline illustrates Mr. Anderson could not have done this, the fact that no one puts him there on May 17th, 2020, the fact that there is no blood in the van, there's no body, there are no remains, there's no murder weapon. They still are going with the fact that Mr. Anderson committed this crime. That's because, remember, that's who they chose as their main character. They ignored, and by they I mean law enforcement, ignored legitimate leads and follow-ups, suspicious people. And they ignored that people? Because on May 19th, 2020, when law enforcement met with Sadie outside of Mr. Gutierrez's apartment, she said, my ex had something to do with it. And they said, great, let's run with it. We're going to try to build a case around him, even if we don't have a body. We have no explanation of what happened to him. We have no explanation of where Mr. Anderson would have put a body. We're going to run with him. So what did they ignore? They ignored Miss Beecham. Miss Beecham, as the state noted, went to Mr. Gutierrez's residence at around 11 a.m. on Monday, May 19th, 2020. She had only been dating this guy for a couple months. This guy was dating other people. They only saw each other every other weekend, some weekends. It wasn't a hot and heavy relationship like the state wants it to purport. The evidence isn't going to show that. So she's only been dating this guy for a couple months, a guy she met off of Facebook dating, and decides, you know what, haven't heard from him. I'm going to go to his house in the middle of the day when he would be working to see what's up. Sure, there could be innocent explanations to that, but you'll also hear evidence that Miss Beecham had constantly been texting with her best friend, Rebecca Jekyll, about how she thinks Zach's tracking her but can't prove anything. She says that. She says that to Rebecca Jekyll, and she's complaining about it. And this is all on 5/14/2020. She's complaining about it. Text messages between her and her best friend, Rebecca Jekyll. And on May 14th, 2020, Rebecca Jekyll randomly texts Sadie Beecham and says, in this discussion string where they're discussing how she, is so irritated with Mr. Anderson, Miss Jekyll sends a random out-of-place text that says, phone call has been placed. All I was told is it will begin and you will not know when, where, or how. Call me in 1 week. And what's 1 week later? When she's at Mr. Gutierrez's apartment. So, if we could have the objection outside the presence of the jury.
So there's an objection because she's basically saying.
What did you say?
I do want to do it outside the presence of the jury. I apologize. This thread is something that we've litigated prior.
Generally, folks.
Apologize.
Quiet, please. I'm going to ask you to step just into the library. If somebody needs to go upstairs, you're welcome to do so, but come right back down. But go into the library, and I don't think this will take long, and make yourselves comfortable there, please. Don't talk about the case, please.
So the audience, everyone stands for the jury. This is nice. We like seeing that again. I've slowed it back down to normal speed. Because now we're going to have the objection. And you're going to hear something called Denny here. So listen for what Denny is, because they say it at the very beginning And then they just reference Denny, a Denny case or a Denny issue and things like that. So you'll need to know what Denny means. It's very pertinent to this case. Jury heads to the library. They all get coloring books or whatever they want there. Maybe an audio book on tape. Sit down on the beanbag chairs.
Gravely, I hadn't pressed the button. That's why.
My objection is that the defense line of argument that's just been stated regarding Sadie Beecham is a violation of State v. Denny. To be able to name a party and indicate that there are factual circumstances that are consistent with them being guilty of procuring this homicide in the alternative is exactly what Denny was designed to prevent. The court is aware that Denny asks that the defense file a written motion giving all parties notice so that the parties do not, in mid-trial, have alternative actual named parties be described, as well as factual circumstances which are designed to cause the jury to suspect that person is an alternative individual. This is exactly what Denny was designed to prevent. And now the name Sadie Beecham has been associated with this jury with being involved in planning a homicide of this individual, and that's in direct violation. There is no doubt that the defense is on notice as to what Denny is or its expectations. We litigated a Denny motion just last week where they laid out a direct foundation. These are, again, the quoting to the jury are text messages. These are not new pieces of information. And frankly, as I indicated in the prior Denny motion, the court has an obligation as a steward of this information to be sure that all parties are dealt with fairly here. We are required to be able to be provided notice if individuals are out there in that situation and be able to defend those individuals, and the court is required to rule on this beforehand. So I believe this to be an improper argument. I don't think it can be cured at this point, and so I ask the court to consider what our remedies are, but I believe that this is a clear Denny violation and that this is a mistrial.
Boom, mistrial.
If I may be heard, Judge.
During opening statements,
Thank you.
call for mistrial.
In my opening statement before I started going into this sequence, I talked about how law enforcement did not follow up or look into anything as far as possible other suspects or leads. I'm not offering this, and first of all, I'm just talking about the evidence that's going to come in, right? At this point, this is what the opening statement's for. This is a message string between Miss Beecham and another witness. This will come in, and it's not to offer it, Judge. It's not to offer it to say it was her. It's to offer it to show that law enforcement did not investigate her, did not investigate anyone else. That's not a Denny motion. I'm not pointing the finger. I'm not saying Miss Beecham did it. I'm saying they could have followed up on this, they should have followed up on this, and they didn't. It's very different.
First of all, you're telling me it's not coming in. And if it's not coming in, then you're not supposed to talk about it.
No, I said it is coming in, that this will come in through witnesses.
Say it wasn't going to come in.
No, sorry if
I heard you wrong.
Okay.
Did you want to respond, Mr. Waverly?
Yeah, you can talk about whatever purpose you want. The argument made to the jury is other people should have been looked at. I mean, you couldn't be more clear in your argument. The argument was other people did this crime. My client did not, other people did. Here's example one. And she's now laid out specific electronic evidence that she wants the jury to be presented. So not only is she making an accusation, the substance of this accusation is that Sadie Beecham and a friend of hers have conspired to find a third party who will kill this person. That's the allegation that's been just made. And she's indicating that's what the text would lead a reasonable person to believe. There's been no notice of that specific allegation. The jury has now heard it. It's been shared with the jury. There's a whole body of case law in Wisconsin that does not allow a private citizen to be accused. And for a person to say, well, that's not for the purpose of accusing another human being of murder, that's what she's done. That's the argument that's been made. It doesn't matter if that is not if that's not the sole purpose you have. Your objective here is to tell the jury, hey, there's reasonable doubt. Sadie Beecham did this. Look at this electronic message. That's why you argue that. There's no other reasonable argument as to why this has been shared with the jury. And why weren't we given notice of this? Why wasn't, when a Denny motion was filed with all the details, and I complimented the defense just a week ago when they provided their factual circumstances so the court could litigate that with the state, because I believe that's the entire proper procedure. I'm on record as having complimented them for supplementing and providing a factual basis for the court to make a fair ruling. And we are in complete absence of that in this situation. This can't be remedied. Sadie Beecham has been accused of murder when Denny exists as
saying this can't be remedied
in this state.
Is we need a mistrial.
If I may respond.
Go ahead.
Thank you, Judge. I have not accused anyone of anything. I think it's been very clear that the defense is saying that none of this evidence exists, and law enforcement, instead of doing their jobs to investigate, just went with a single individual, that they had tunnel vision. An extremely proper defense, and this does not fall under Denny, is to say what the law enforcement didn't do. I'm not here to purport that this is what happened, nor have I said that. During trial, it'll be, this message was sent. Hey, detective, were you aware of this? Did you look into it? Do you think it's a little bizarre? Yeah. And leave it at that. Nowhere have I just said right now that I intend on pinning this all on Miss Beecham, nor have I think that has been the theme of my opening statement.
But if you don't have...
He named her, and it's talking about...
Greater information than that.
She named her in a text exchange.
Why is it relevant? I mean, what difference would it make whether the police followed through on it or not, unless there's reason to believe that that was the person who was responsible for the disappearance of the decedent? It's irrelevant, and I mean, I'm hoping they didn't investigate me too, or Mr. Gravely, or Ms. Grzarek. They'd have to have a reason to do that. And if there isn't abundant reason to suspect that Ms. Beecham was involved, then I think Mr. Gravely is quite right. This is just a camouflaged Denny effort.
The defense would respectfully disagree with that, Your Honor. By sustaining the state's objection, the court would ultimately be holding that the defense cannot go into how law enforcement didn't do their job, which in a case where there's no body, no evidence of human remains... Why didn't you file a motion? It's not a Denny motion. I'm not offering this to point the finger at someone to say, this person did the crime.
I have an alternative actor theory.
It's not an alternative actor theory, and if I could maybe give a preview to what was going to come next, is the 20 other things that law enforcement didn't follow up on. It's more targeted, if I may finish, it's more targeted to what law enforcement did or did not do, opposed to what some third party did or did not do. That is what this is going towards, and the defense would maintain that that is extremely relevant. It does not fall under the curtails of Denny, and that we are permitted to go into that in opening argument and during the pendency of this trial.
Okay, I want to be heard on the precise thing that was said by the defense, because this
turn your microphone on.
A disingenuous argument to say, my argument is just a police officer, here's the text message, isn't this weird? That's what she just told you. Here's what she represented to the jury. She said
this is a murder trial.
She read the text message and said,
we're just starting at the beginning.
This mysterious third party will take care of this, but you won't know the details, and we'll know in a week, right? And then she said, she commented to the jury, and a week is when Sadie Beecham goes and discovers this bloody scene. So she ties it in. She says, guess what, jury? At the end of the week, it's Sadie Beecham who, in response to this message, has now made this discovery. This is implicating Sadie Beecham directly in a homicide. That's the only reason you make that argument. She didn't remark, and I didn't object when she first began to speak. What she told the jury was that this is bolstered by Sadie Beecham being the person who discovers this scene a week later, which is in accordance with the detail with the text. This should not be investigated by the state on the fly. This is just not Denny does not allow a scenario where a fellow human being can be accused of a homicide and the state is expected to figure out on the fly what this information leads to. The jury has every reasonable expectation right now that Sadie Beecham could be the killer based on what's been said. That should never, ever be said in a courtroom until Denny is litigated, ever. I mean, this is a line that it's not even a close line that's being crossed here. And we remedied for this jury.
What I was going to say before the objection came was that even just, okay, so it's still, again, not being offered to point the finger at her. And I'm not
frankly, your Denny motion that I denied with respect to Mr. Campbell, I might have granted the one on this one because there is not more body to it. So I think Mr. Gravely correctly is concerned that this is just, as I said, a camouflaged Denny motion or effort.
I disagree. The defense disagrees. This is law enforcement. So we can't go into how law enforcement investigated this crime then. Would ultimately be the court's holding. Because there's
that's not the court's holding.
So why didn't you investigate the person who just happened to find all of this? So is that pointing the finger?
That's not the issue before me. This isn't midway through the trial that you didn't ask some probing questions of the detective if he testifies. And ask, well, did you look at this? Did you look at that? To try to show a sloppy investigation, if you think it was. This is in your opening statement and planting a seed and it's all right to plant seeds, that's why we have opening statements, but this particular one has a special body of law handed down to us from the Supreme Court of the United States, and as I say, you correctly brought the Denny motion on Mr. Campbell's issue, but I think this is, well, it's in the same category.
If I can further be heard.
Yeah.
So what is the difference then between saying law enforcement, because I do anticipate talking to Carrera and other detectives about these messages, about whether they looked into any other possible individuals, which is not a Denny motion. And so what's the difference between me saying to a jury in an opening statement, which is what I believe the evidence that's going to come in is going to come in, that this message is going to come in and law enforcement did not follow up on that?
I'm not going to pre-screen what you might or might not ask.
But I'm saying
you're capable of making your own decision about whether you want to ask the question and what the risk would be. But this is a concrete issue that is before me now, and I think it's correctly analyzed by the state, and what I'm struggling with is what to do about it.
Well, Judge, frankly, a Denny requires notice. So this jury is tainted. We need the court to provide us an opportunity for, if this is an argument they wish to make with an individual identified, they need to notice us, provide us what the factual basis is they're going to allege, and allow us to counter that. This is what happened with the Campbell situation, right? We had the police look at their information, do an investigation that would allow the court to be provided both sides of what that information would entail. And then the court is able to make an educated gatekeeper determination. That wasn't done here. Counsel would be prohibited from arguing an opening or closing without Denny guidance, without the court gatekeeping under Denny any of this information. So under whatever shield they want to use, whatever they want to label it, it still can't be argued in opening or closing as something that is alleged in this case unless the court gives them permission. This is a mistrial. You cannot take away a suspect from a jury. You can't do it. And they should provide the proper notice, as Denny requires, as they did on the prior attempt, and we should have a chance to litigate that before this court. And it shouldn't be a day's notice. It should be sufficient notice for the state to do a real investigation.
Dun, dun, dun.
Naturally, the defense is maintaining that this isn't a Denny issue. As far as notice, if this is concerned that this text message is coming out of nowhere, these are records that were provided by the state. These are records that the detectives in this matter have went through months ago. They've seen this text message, and if they haven't, that's on them. It's not my fault to make sure they've looked at every piece of paper in the discovery that they provided to me. I found it. I intend to use it to show that law enforcement honed in on my client and didn't investigate anything else.
So it's basically the same defense we heard.
That's not a Denny issue.
In the Murdaugh trial.
So as far as notice, the state's had this information. I'm not using it to point the finger at Sadie. I'm using it to point the finger at the fact that law enforcement did not do an effective job investigating and instead painted my client in a certain way. And as the court's aware, this is a bodiless homicide. There's no human remains. There's nothing. And the investigation of law enforcement should be the focus of a defense here.
I'm not sure that it makes any difference whether there's a body or not in terms of this particular issue. But
okay, we've got a few more minutes and they're going to break for lunch.
now, before we break, so that I can look at the authorities on this again.
We won't break for lunch with them. We're going to watch the rest of this day, which is only another hour after this, and then we'll have our lunch break. So we'll have half a day done. We'll have 1 day done in half of our day.
Well, ordinarily I
So
have
we're
an
gonna catch
individual
up.
colloquy with the defendant when there's a motion for mistrial about jeopardy. And actually, the first case here was dismissed without finding on jeopardy. I didn't have. Ended up as a motion to dismiss without prejudice.
I don't know the details of case number one, why it was
And I'm not
declared a
obliged
mistrial.
to go through a waiver colloquy with you, but you need to understand that if you're wrong about this, and I agree with you and am wrong about it, you're done.
Yeah, I'm aware that the appellate court makes its own decision on these matters. I'm aware of that. I'm aware that the body of law indicates that if the court makes discretionary decisions, and if the Court of Appeals agrees with the court's exercise of discretion that the defense has engaged in a form of misconduct in this case, that jeopardy does not attach. So, I understand that the Court of Appeals could disagree with the court's exercise of discretion, but I believe that is the litigation that would take place.
Well, you refer to it as an act of misconduct by the defense. It could be an act of mistake by the defense.
Absolutely. Right.
Yeah.
When I say misconduct, I mean it in the broadest sense. Yeah.
Okay.
But clearly it was a deliberate argument, and it was a deliberate decision to not file a Denny motion. So this is not an accident. It may be a disagreement about the law, but this is not accidental conduct.
Well, I don't want to get into that, other than to say I made a comment that I thought her argument on this issue would have probably been stronger than I didn't say probably, I said was stronger than the one with the other.
Thank you, Misty, for your support.
I don't know, I'm stumbling.
Campbell. Right.
Looks like month 2 for you as well. Thank you so much.
But she could have also, in good faith, thought the other way, and she brought the one on Campbell, and I denied that. Maybe she felt that was the stronger. That's not deliberate. That's a deliberate choice for her to bring that particular motion, but it doesn't mean she thought that she was bringing the weaker of the two. That doesn't make any sense.
No, she has an obligation to bring a Denny as to each one.
I agree.
Yeah, it's not like an appellate.
But you're saying it was
Also, if I may, I'm
Please.
here and can make the record myself of why I did
You
something.
know what? She's a wonderful, experienced, fantastic reporter, and she's trained.
You're talking about
If
stuff.
more than one person is talking at the same time, take the judge.
Take the judge.
Judge
is not like being talked over.
I don't doubt she could probably take heated discussions, 2 or 3 lawyers at one time. But I don't want to rely on that. You're all talking. And when I start talking, not because I'm so bright or so capable, but just because you're talking to the air, it won't get into the record, or you can't count on it being in the record. So I'm talking. So
please don't
and I've
interrupt
forgotten
me.
what I wanted to say. Yeah, you know, I don't want to get into purposeful. Well, it was purposeful, but whether it was a willful matter is willful in the sense of trying to avoid application of the rule. I'm not in that situation. I don't have to be.
Right.
But it needs to be understood, and you can say for the Court of Appeals, if there is an appeal out of this issue, your thoughts on the subject of whether her conduct was improper or careless or purposeful in a negative sense. So I'm not going to even touch that right now. I do want to look at the exact statement again, and I'll take another look at Denny and the prior Supreme Court decision, and I'll ask the jury to return at 1:30. And, well, actually, I'll ask them to return at 1:45. And we'll talk about legal issues.
Their times are different
when
because
we
we're
get back here
on replay, so don't worry about the
at 1:30.
timestamps.
Any question?
No.
No question. A request, though, if the court could review the statements that I had made prior to my statements about Sadie Beecham as well, because I think that provides the court context as to why those statements were made.
How far back do you want?
To the point that I talked about how law enforcement didn't look into things that should have been followed up on.
I don't think that was a great stretch of time.
No, it wasn't. It was
2 or 3
probably
minutes.
like 2 minutes prior to that statement.
Dallas
All
Born
right.
Boston Bread, thank you for gifting a membership.
Would you?
Looks like
Do you have enough time?
JoJo.
We're back at 1:30.
Congratulations.
Thank you.
Let's get the jury in. Oh. What is the question?
You want to? Can they just stay?
Jury is going to come in.
Oh, okay.
Just for a moment.
You're going to see how he brings the jury back. This is sort of funny in this trial, in this courtroom.
What do you want to do?
The sheriff was about to haul.
I'm okay with you just.
Haul
You always
ZA.
make it come out well.
Judge, I'm all right with you. The court just communicating with the jury that we're adjourned until 1:30. If the court wishes to do that, just by either note or. But if the court wishes to bring them down, that's fine too. I just am suggesting. That's okay.
I don't like to talk to the jury unless it's on the record.
Okay.
So this is just going to take a minute.
Oh,
Oh, there
thank
it is.
you.
Okay.
I guess just put it down.
He didn't actually have to go in the back. Oh, okay.
Okay. So this is interesting. Basically, the judge told the prosecutors, look, we've had a mistrial previously, and on this one, if you're wrong, you can't, it'll be like double jeopardy. We're not going to let you bring this again. So there's incentive for the prosecution to get this call right. So if they really ask for a mistrial, that's going to be, and the appellate rules against him, he's basically, he gets out. That's my understanding. They can't bring charges again. These same charges anyway. So so there's incentive for the state to sort of work through this
All right, folks,
and move forward.
I'm glad I told you that was going to take about 20 minutes. I did tell you 20, didn't I? Did I say 5?
Yep.
Well, anyway,
Alex.
we're still working on a legal issue, and I think it's an appropriate time for a break. So I'm going to ask that you return at 1:45, and that'll give you a break. And also, we do have some more legal issues to discuss, and we delayed the other one. So I'm going to spend at least 15 minutes with the lawyers, and the poor reporter she's been working since start, and now I wanted her to type a little part of the transcript, so it's going to be a little bit of time. But I'm hoping if you're here at 1:45, we'll get to you. 1:45. We'll get to you shortly after that. Please don't talk about the case. Read, watch, or listen to any account of the trial. Any question?
Bring the jury.
Okay, thank you very much.
Okay, so the jury here gets kicked out. We're at 3:32. I believe, let me just check here just for a second. I think we're going to skip ahead just a little bit till after the lunch break because I don't think they really talk much to the... I don't think they talk a lot to the lawyers. Well, let's see. Oh, no. There's one more hour from today. That's it. An hour and 11 minutes, I think, total. We might watch it a little bit faster, but it's continued discussion on this, about the objection, about the remedy, what they can do.
Just tell the bailiffs to get them out of here.
Get them out of here.
Yeah.
And there's a request for something that goes off, something about transcribed.
It's for her.
The audio gets better in this trial as we go along. This is day one, and it's sort of quite glitchy. There's a couple points that has some clicking and stuff through it we're going to have to sit through, but we'll try to speed that up as much as possible.
Oh, I told him that would be a good time. I tell him he's got to, if he wants to come.
They're just talking, and they just slowly fade the mics like they don't know if it's supposed to be on or off. At 75 years old, Schroeder's the longest-serving circuit judge in Wisconsin. He's very much used to running that courtroom the way he wants. Very, very insightful, Andy. When you get an opportunity, please fill us all in on the nitty-gritties. Thank you. Well, basically, we're starting at the beginning.
I'm not a cat.
I'm not a camel. We're starting at the beginning, just where we can get an idea for what the state is trying to present and what the defense is going to present and what their stance is. Yes, it is bad that it's a man bun. There's not much I can do about that, unless somebody cuts his hair for him mid trial. Let's see. I talked to Recovery Adequate, planned all this out, so give it another hour and it should all fall apart. Yeah. So where it stands right now is the defense has not finished their opening statement. There's been an objection because the defense raised the girl who's been shown several times in the gallery. That's the girl whose boyfriend was murdered, and the defense is saying it may have been her that was involved. That she might have conspired with somebody else to have him killed because of this weird text message that nobody understands what it means, and it happens to coincide exactly with the day he went missing. And so they've presented this information and said, hey, the state has not looked at anyone else, just like we saw in the Alex Murdaugh trial. SLED immediately, he was our man, he was our suspect. There's nobody else in that circle. It's the same sort of defense, saying they immediately pinned it on him and haven't looked at anybody else, when they should have looked at other people like Sadie because of this email and this other friend, and said this is going to be a week. And at that point, there was the objection saying that's a Denny issue. This is a problem where you're naming another suspect and not giving us notice and everything, and there's case law for that, for how that has to be done, and it can't be. You can't just bring it up now. And as they say, now it's too late. You can't put the genie back in the bottle, and so the jury's heard Sadie's name as a possible involvement, in this murder. You can't let them unhear that, and so now they're going to discuss this some more, and they're going to actually get a remedy. I'll tell you that. But let's see what we do. We've got to jump ahead to 4:55. 1 second. Let's see. There's a I think we're right here. Okay, so there's been a lot of discussion happening here. The video's been going, but the mics were off the whole time. And the two sides were sort of conversing with each other a little bit and negotiating and things like that. So we're about to get the mics back on here in just about a minute here. Okay. Now the client's brought back in, so the client doesn't know what's going on either.
The appearances are as before.
Everything was off the record.
Anything further to be stated?
There will be further argument from the defense. Attorney O'Bear will be handling that.
This is on the same issue, I believe.
You have the floor.
Make sure I'm turned on here. Okay.
Oh, you are.
We did some
And
more
they do-
research.
they do a
over
lot of
lunch
arguments
hour,
from the
and
seated
I wanted
position in
to
this
point
court.
a couple of things out. First of all, in the context of the particulars of this case, it's very obvious that the defense is that Mr. Anderson did not commit the offense. So this is not one of those defenses where we're attacking an intent element or the manner in which something was performed. Our theory, of course, as the court is well aware, is that he didn't commit this alleged crime. The comments that were being made by Attorney Mueller during her opening statement were part of a larger argument and in proximity to the point that she had just previously made, which is that that the investigation focused solely on Mr. Anderson. And in fact, the words that she made in terms of what our whole theme and theory of this case is that there was a script that was written. Mr. Anderson was the central player, the main starring role in this script. Now, as in any case where there is an investigation, and if it's the defense's intent to argue that the defendant did not commit this offense, it's part of virtually every case where reasonable doubt is what we're addressing. Am I not being loud enough? Reasonable doubt? I'll try to talk more directly into it. The angle's funny here. So it's really a matter of looking at what the entire investigation entailed. Everything that Attorney Mueller was discussing in her opening statement was based on information that had been provided by the state. Now, there are a number of different scenarios in which Denny can be applicable. And just taking a step back as to what the purpose of the Denny rule is,
since
is
it really
so
gets in
that
the weeds here.
on a very basic level, the defense can't create some sort of theory that the man on the moon or an alien from outer space came and did it without any support for that. But on another level, if, let's say, in the course of a defense investigation, evidence is uncovered that could theoretically point to a third-party perpetrator, the reason for the notice and procedural rules behind that scenario is that the state then should be given the opportunity to investigate with their resources as to the viability of that potential third-party candidate. This is different from that in the sense that we're talking about evidence that was turned over from the prosecution to the defense, and our point here is merely that, and this is one of several different points, things that were not followed up on. So what I was looking at over the lunch hour is, interestingly, some aspects of the Kiles versus Whitley case, which the court's very familiar with from 1995. Now that case initially, of course, resulted in a reversal of a conviction and a death penalty based on the fact that there had been withholding of exculpatory evidence.
Counsel, can you cite so that the parties have a chance to read it as well?
It's Kiles versus Whitley, 514 U.S. 419. 514 U.S. 419, United States Supreme Court. That case had to do with the fact that there was evidence that had been gathered by the state or the prosecutors in that case. And a decade after the conviction had occurred, it was reversed because it was determined that there was important information that the state had not provided to the defense. And it's interesting to note why the Supreme Court found that that information was vital to the defense. And it's basically precisely what we're talking about here. The Supreme Court held that it would have and should have been useful for the defense to be able to establish that the investigation was shoddy. It could have raised opportunities to attack not only the probative value of crucial physical evidence and the circumstances in which it was found, but the thoroughness and even the good faith of the investigation as well. Their disclosures would have revealed a remarkably uncritical attitude on the part of the police. The defense could have examined the police to good effect on their knowledge of another party's statements, so have attacked the reliability of the investigation in failing to even consider other parties' possible guilt. This is right out of the decision. A common trial tactic of defense lawyers is to discredit the caliber of the investigation or the decision to charge the defendant. This was, and put in context, this was evidence that back then the prosecution believed wasn't exculpatory. Whether it was negligently not provided or deliberately not provided doesn't really matter. But the point is that Kyle's specifically acknowledges the legitimacy of attacking.
If you guys want, we can skip this argument
the negligence
because it's
of the
really in the
by the
weeds
police
about
that were not anywhere within
about what's
the means
happening
or the control of a defendant or a defendant's attorney's investigation into the case. I'd also just point out, I'm sure the court is absolutely well aware of this, that when the state makes a motion for a mistrial and when the defense objects, the standard is manifest injustice. And I don't think it rises to that level.
Okay.
So again, I think that what Attorney Mueller was doing here.
Let me summarize what's going to happen here then.
With her entire presentation
as I turn this down. Adam likes the weeds. Adam, you're going to have to watch it on your own, unfortunately. What's happening? Let me just turn down their audio just for a minute. What's happening? They're arguing back and forth. The state has objected to this mistrial call, basically, the objection. The state's on one side, they're on the other. They're going to argue back and forth. The judge is sort of going to rule in the middle, and he's going to say, it sort of was a problem. Okay, it was sort of a problem. It doesn't really rise to the level of a mistrial, but we have to do something to remedy it. And so because you've brought up this allegation, basically, a loosely veiled allegation that this Sadie was involved, we're going to allow the prosecution to bring in another witness specific to that allegation to counter your argument. And that's how we're going to remedy the situation that you've created by bringing up this Denny issue that, you should have handled differently and you didn't. And that way we get around the mistrial and we get to move forward. So there's a lot of spicy back and forth in this, and it sort of lays the groundwork for some of the hard feelings in this trial, because there are between these two sides. And I do think it was a fair ruling, because she barely broached the subject. It was more implied, and she is allowed to bring up the state didn't investigate properly. It should have been done a little bit differently. So I think it preserved the record, so to speak, that everything can continue in this trial without that. So I'm going to go ahead and wrap up. Let me switch to this view just for a second. We'll turn off that. Oops. Not sure why I started recording on the podcast machine. We're going to jump over to the next video. Give me just 1 second. That one's going to be picking up. So the next video picks up, it's actually short, and this is day 2. Okay, so that was the end of day 1. So day 2 is extremely short. We've got like we've got less than 20 minutes. Okay, so we'll start at 2:43.
And the lawyers were kind enough to take the time to sit down and confer with one another. And
this is day 2.
There was also a submission by the defense, which I did review. And why don't you take it from there, Mr. Gravely?
So counsel will correct me if I make any representations she did not feel are completely accurate, but I believe that
this tie is a crime. I'm not sure. It's just an overhand,
believe that,
not
based on
the
filing submitted by the defense, that the state and the defense have an understanding that the defense will not make any arguments that rise to the level of a Denny argument, and not present any evidence that will rise to the level of a Denny argument. And they recognize that the argument that the state believed was a Denny argument was a sort of a connect the dots argument of some individual pieces of evidence, and they've indicated they will not make that sort of connect the dot argument that would rise to the level of Denny, and their submission reflects that. They have indicated to the court they have no additional Denny hearings that they are seeking from the court, even though the court gave them guidance if there was Denny-like evidence that they should put it in their submission. In light of that, and understanding that I believe that to be an accurate interpretation of what they wish their filing to represent to the court, The parties were able to come up with a joint proposed cautionary instruction so that we did not have to have a mistrial in light of that pleading. That joint proposed cautionary instruction has been submitted to the court. All parties have copies. Does the court need me to read it, or does it stand in this record because it is a final document?
He probably doesn't know how to tie a
I'll
tie.
leave it to your
That's my
choice,
guess.
or that of the other party. It doesn't need to be, but you're welcome to do so.
Well, I have no reason to. Do you, counsel? Okay, so we've come up with a joint proposed cautionary instruction. We're asking the court that be read at the conclusion of the defense's opening statement. That was the express preference by the defense counsel, which the state is fine with, so that it is in close proximity to the end of the defense opening statement. The court certainly will use its own discretion about whether it should be read at any other time, but that is the time that we are asking the court specifically to read it. The state is also requesting to the court that in light of the sort of connect the dots argument made by the defense, that the state be able to add to its witness list and to call in its case in chief a witness named Rebecca Jekyll. That's Jaeckel. We intend to present some evidence to refute the implications that were raised in the defense opening argument. And I don't believe the defense has any issue with that. I believe that's the entirety of our discussions. Is that, counsel, does that? Yeah. So I believe that is the entirety of our joint discussions.
All right. Is that a fair statement?
Yes, hold on one second.
Yeah.
Okay, so they've agreed to this back and forth. She's going to say there's just one little change or one, just make something clear. Judge, like a little louder in this ear. This is a really short day. So I don't believe the jury's even here this day. They didn't bring him in today.
All right. So is that a fair statement of the situation?
Yes, with some caveat, but it is a fair statement. The caveat is that my conversations with the district attorney, as it relates to how I could perceive how he interpreted the statements made in my opening statement, I had told him that I could see how he would interpret it that way and how someone could interpret it that way, but that I'd hope he could see that we could also interpret it, the defense could interpret it in the way that we so proposed on Tuesday and also in our pleading to the court. And so there was kind of that mutual understanding that it could be seen both ways is kind of my understanding of that conversation. And so that was why we found it amenable to prepare this proposed cautionary instruction, and that would really cure any concerns that the state would have as it related to the statements that were made during the opening. As far as when we are requesting it to be read, the state's assertion was correct, that we're asking that it be read at the conclusion of the defense's opening statement. And then with Ms. Rebecca Jekyll being added to the state's witness list, naturally no objection. She was on ours. I did confirm with the state that they will write up a summary of what was discussed with her about this text message that will be prepared and provided to the defense prior to her testifying. So we will have that information and can act accordingly when we receive it. So that's the only supplement that I have, Judge, but I think that what the state and myself have come to an agreement on is appropriate, and that the court should accept it and should allow this trial to continue.
That was a long way to say yes.
The motion of the state for mistrial?
Frankly, what we've tried to figure out is a way to move on at this point. So yeah, I'm withdrawing the motion for mistrial in light of the stipulations and the filing so that we can keep going.
So we get to move forward.
What did I do in my life to merit such congenial attorneys? No, this is, well, I'll leave it at that. No, this is not something which would reach an element of the offense. Well, that's what I'll reach. This doesn't actually constitute an element of the offense charged. So I don't think we need to obtain the consent of the defendant, but I assume he's familiar with the agreement and what it means.
He's not.
You want to discuss it a little bit more with your attorneys, you're welcome to do so.
If we could just have a brief moment. Naturally, I was not able to confer with my client. Should we go in the back?
Yep.
Thank you.
Okay, so this is interesting because the lawyers just made a huge deal about how what they agreed to with the case, how they can move forward and everything, whether they can withdraw the mistrial objection, and the defendant has no clue what's going on because the defendant does not run his defense, right?
he can provide input and encourage and provide information and stuff. But really, the lawyer is, I mean, you don't tell your doctor what to do, how to treat you, right? You go to the doctor, and the doctor's got the experience. It's like, well, based on what I see, this is how we're going to move forward. And so the defense has done that with here, and they've reached this saying this is the best possible solution. This is what we should do. This is the right way forward. And now they're going to inform him. He's going to be, okay, I'm good with that. So let's jump ahead. We'll skip this little break. Let's see, we go to 1540.
Yeah, I usually go. That I don't let the lawyers participate.
Mr. Grisark is not aware of that, evidently.
We're going to catch up so we can watch this live. That's the goal.
Down, but and I will tell you that a former
I don't know what's wrong with the ceiling in that corner. It's missing some ceiling tiles in that picture.
So ancient
actually times. Ended at, what's that?
Ancient times.
Ancient times.
Yeah.
Actually walked out of here with a negative score for the year.
They're just BSing. This is like off the record. It has nothing to do with the court.
But he's impulsive and he guesses too quickly. Yeah. All right, I guess we got to go to work.
I have a couple of theories, but.
So you've had a chance to talk with your client?
Thank you. Yes, Judge.
Okay. Do you have any questions about this at all, Mr. Anderson?
No. Judge is talking to you.
Okay, any problems? Okay. All right.
Back at 9?
I will accept and approve the stipulation, and it will be given as you request. If I remember to do it, at the close of your remarks, and if I do forget, just
I will remind you.
Me. And other than that, I think back at 9 o'clock. And anything else?
No.
Nothing.
All right.
Thank you.
Enjoy this magnificent day. First day of meteorological spring.
Okay, so we are catching up. We're a few days behind, but this was the end of day 2 now. So we have done in half a day, we have taken care of catching up with 2 days of trial in here. So we're going to get back to speed. The whole goal is here is the next day or so to be back to be able to watch this live as it develops, so that it's new to us as it happens, and it'll all be good. So we've got 11:30 right now. I can
just subject matter jurisdiction.
Let's see. I can start.
Interact with that individual.
Oops, sorry. Day 3, 1, 2, and 3 starts at 5. If you can't tell, I spent all morning trying to get all these timestamps and everything right, just so I could speed this up, because this trial's fun. But I would hate to start like right with what they're happening right now, because they've already had a couple days of testimony, and a lot of breaks and a lot of spiciness. I didn't want to miss that. So now we've got, let's see, that was day 1. We've watched day 2. Now we've got to end the defense's opening statement, which only goes for like 15 minutes or so, 20 minutes maybe. We're going to watch that on high speed as well, if that's all right. We're doing 1.25 speed, so it's not super fast, but I am trying to catch up. So that's going to start here right now, right?
Decided that the objection was
the jury just comes in. Here we go. Jury comes in.
Back, and we had some discussion, and then the attorneys consulted, and it's decided that the objection which was raised by Mr. Gravely has been withdrawn. So we'll continue where we were. Thank you.
So we're back
Good
to
morning, everyone.
Opening statements.
So where I had left off when I last was speaking with you all was about how law enforcement in this case failed to actually investigate the events the state assert transpired on May 17th, 2020. How they ignored leads, how they didn't follow up on things, how they failed to look in places that should have been looked into. So I'm going to go into some of those investigative failures now. You'll hear that law enforcement really did no searches of Mr. Gutierrez around the immediate vicinity of Wood Creek Apartments, where Mr. Gutierrez lived. That there's a wooded park area that is property of UW Parkside, and that all that they did with that area was send some drones to look around. But you'll hear that it was forested at that point, because we're in the middle of May, and that they would not have been able to see the floor of that entire wooded area. So law enforcement looked nowhere close to Mr. Gutierrez's residence in an attempt to find potential evidence. Not only did they fail to do that, they failed to investigate legitimate Crime Stopper leads. So people could call in with tips, anonymous or not, and there was this one tip where an individual called in and said, I saw a woman standing in front of Mr. Gutierrez's sliding door on that concrete slabbed patio on May 18th, 2020. And I remember this because she had asked me what time it was. And I knew it was Mr. Gutierrez's apartment because his sliding door is right next to that exit door. Law enforcement got that information and ignored it. They did not follow up. They also didn't follow up on data that they obtained through a geofence warrant. And you'll hear that a geofence warrant is where law enforcement takes a certain area and asks Google to produce all the information and data on people that they know were in that location on a specific date and during specific time frames. And in this case, Detective Carrera had asked for the geofence data on all individuals who were around Mr. Gutierrez's apartment from May 17th, 2020 at 7 p.m. through May 18th, 2020 at 3 a.m. And that Google produced several hits for people that were in that area. And you'll hear that law enforcement did not attempt to investigate any of those potential people who were in the area at the time the state asserts the crime occurred. You'll also hear that Mr. Anderson did not appear in that data. When law enforcement arrived on scene on May 19th, 2020, there were two dumpsters next to Mr. Gutierrez's apartment, and they had gone and looked at them and noticed that there really was not that much trash. Maybe a bag, a box, and so they called the waste management company and they asked, hey, when was this trash picked up? And the waste management individuals had informed them that the trash had been picked up earlier that morning on the 19th and that it was sent to Zion landfill in Illinois. You'll hear that law enforcement chose not to go to Zion landfill and search what would have been freshly dumped garbage that could have produced evidence in this crime.
Or a body.
And you'll hear that that could have been because Mr. Anderson, the person, remember, that they had chose as their main character, there was no indication that he had ever gone out to Zion or that he had spent any significant time in the Kenosha area. Didn't fit their script. They weren't going to investigate it. They also didn't investigate Pheasant Run landfill. That was a landfill that they had potential information that Mr. Gutierrez's body had been dumped there. They didn't go to Pheasant Run landfill. They didn't talk to anyone in management at Pheasant Run landfill to see whether there was any individual who dumped off trash that Monday, May 18th, that morning. They did not investigate that lead. They also didn't investigate people that Mr. Gutierrez owed money to. And you'll hear throughout this case that Mr. Gutierrez was in an extremely difficult financial situation. His mom was helping paying bills. He was about to be evicted from his apartment. And he had people messaging him about where their money is and how you don't do this to friends. And you'll hear that law enforcement did not investigate a single person that he seemed to owe a substantial amount of money to. And then they also didn't look into all of the women that Mr. Gutierrez would have been talking to or dating at that time. You'll hear that Mr. Gutierrez had several dating apps. They were located on his phone. He had emails from dating websites, and that law enforcement didn't look into any of the chat strings on there. And that's just the tip of the iceberg. What I just outlined for you is just a little sprinkle of an example of everything that law enforcement failed to investigate. But not only did they fail to investigate legitimate leads and potential other suspects, they also failed to effectively process the scene of the crime. They failed to obtain DNA swabs, fingerprints from areas that, according to their theory, the individual or individuals who was responsible for the disappearance of Mr. Gutierrez would have had to have touched or come in contact with. The first thing law enforcement did when they arrived on scene on May 19th, 2020 was they took a video of them walking into the apartment, of Mr. Gutierrez's apartment, and all of the lights were off. So the state claims that there was this blunt force trauma, this beating, someone was wrapped up in a rug, the crime scene was meticulously cleaned up so that no trace of the other people who were there could be found, that then the scene is staged to the point that it looks like a robbery could have occurred. That obviously didn't happen all in the dark if they're claiming that this happened around 10 p.m. at night, yet law enforcement did not swab the light switches in the apartment for potential DNA, nor did they attempt to get any fingerprints. In addition to their failure to obtain swabs from areas that could have contained DNA of the people who are actually responsible for Mr. Gutierrez's disappearance, their lack of precision shows immensely in the fact that 9 days after they initially made contact with Mr. Gutierrez's apartment, Mr. Gutierrez's mother, Ms. Patterson, found Mr. Gutierrez's cell phone in the freezer. That law enforcement's there for 8 days. They'll claim that they searched, they processed, they were very thorough, yet they didn't find Mr. Gutierrez's cell phone that was right there in the freezer or the contents of his wallet that were in the freezer. So they did swab the cell phone for DNA, but what they didn't swab or process for fingerprints were the cards that were found, which, according to the state's theory, the person who's involved in Mr. Gutierrez's disappearance would have had to touch, to take out of the wallet, to put in the freezer. And they also didn't process the handle of the freezer. It's also critical that there was no blood on the handle of the freezer. And the phone, interesting enough, the DNA, they send the swab that they took to the crime lab, and it comes back and they say, yep, it's Mr. Gutierrez's DNA on the phone, but there was something that's called a trace allele. And you'll hear from the DNA expert that a trace allele means that it's someone else's DNA, that it's a portion of someone's DNA that did not belong to Mr. Gutierrez, but someone else. And you'll hear that that trace DNA that they found on that cell phone, as I just said, did not belong to Mr. Gutierrez. It did not belong to Ms. Patterson, the individual who found the cell phone, and it did not belong to my client, Mr. Zachariah Anderson. So someone else's DNA is on that phone. You'll also see pictures and hear testimony about how the furniture in Mr. Gutierrez's apartment had been moved. And all of this furniture had been meticulously moved. Nothing's knocked over, nothing's broken. The kitchen table's nicely pushed back. The 2 white tables that were in front of the couch were nicely moved to the side. The couch had been moved, and we can see that because there's indentations in the carpet of where the couch had stayed for a long time versus where it was now. There were no bloody fingerprints or hand marks on the bottom of the couch. They didn't process that for DNA in that area of a couch where the person had allegedly moved it, would have had to have touched. They didn't process the areas of the chairs that would have needed to have been moved, the table that would have needed to have been moved by the person who's allegedly responsible for the disappearance of Mr. Gutierrez. They also didn't process the tools that appear to be nicely laid out in front of the screen door. Nor did they process in Mr. Gutierrez's bedroom the open window. They didn't process that for fingerprints. What did they do? They processed the blood. That was it. Law enforcement's failure to investigate leads and to effectively process a crime scene is critical in this case. There's no body, no human remains, no murder weapon, no witnesses that can tell you exactly what happened. Yet they wanted to go with the narrative that it must have been Mr. Anderson, and that was someone that they looked into everything possible. They ignored everything else. They ignored the idea that it could be anyone else other than Mr. Anderson. And you'll hear that they meticulously searched Mr. Anderson's property, not just his house, his whole property. No body, no human remains, no evidence that there had been a huge cleanup at a crime scene, no murder weapon. Not only did they search his house, they also searched his family's tree farm, an 80-acre farm, top to bottom, multiple law enforcement agencies, every acre, no body, no human remains, no murder weapon, no evidence of a crime scene cleanup.
She does have a birthmark on her cheek.
They also searched Miss Susan Brown Williamson's home, and that was the place that Mr. Anderson had gone in the morning to work that the state claims is where Mr. Anderson, I guess, chopped up a body and put it in bags. They searched that property meticulously, not only the house, but the entire grounds. No body, no human remains, no murder weapon, nothing of evidentiary value. They then searched all of the bodies of water that were near that home and Mr. Anderson's home, not Lake Michigan, but quarries and little lakes. And they had technology that could go all the way down to the bottom to see if there was anything there. That search also revealed nothing. So the person they chose as their main character, the only person they investigated in this case, they did all of that and it yielded nothing.
That's not how you freeze your credit.
Mr. Anderson, as he sits in front of you today, is presumed innocent. And he must stay that way. Because the evidence in this case, as it will come in through this trial, will not establish that Mr. Anderson committed the alleged crimes beyond a reasonable doubt.
It's interesting that Mr. Anderson has
when the defense comes and speaks to you, when the evidence is done, We will ask that you
girlfriend
return the only
pretty much
just
throughout
verdict,
this trial.
and that's a verdict of not guilty.
Okay.
Thank you.
You're welcome. So that was this is day 3. This is the end of the opening statements.
And as I indicated, Trustee, you'll be allowed to take notes if you wish. You're not obliged to. If you do decide to take notes, please take care that it does not distract you from carefully listening to and observing the witnesses. You may use your notes during your deliberations to refresh your recollections. Otherwise, you should keep them confidential. After the trial, the bailiffs will collect the notes and they will be destroyed. Okay.
And all the doodles and artwork and everything.
You can.
As part of my withdrawal of my objection, the court will recall that we proposed a cautionary instruction. So the withdrawal of that motion was based on the cautionary instruction, which I hope the court will read.
I will, and I even told him that you'll have to remind me because I'll probably forget it. Thank you, because I did. This is a joint proposed cautionary instruction that the attorneys have agreed upon, and it states, unless otherwise guided by the court, you must disregard any statement by the attorneys or either of them that any specifically named individual other than the defendant was involved in the alleged homicide of Mr. Gutierrez. Any question about that? This is something they've agreed upon. Unless I tell you otherwise, you should disregard any statement by the attorneys that any specifically named individual other than the defendant was involved in the alleged homicide of Rosalio Gonzalez Jr.
The jurors
Gutierrez Jr. Any question?
The jurors are not allowed to keep their notes. They are all
Mr. Bradley, you
destroyed.
may call your first witness.
Okay. So I'm going to pause right here just for a second. This is where the testimony starts. This is where we start getting a little bit of information, and we're going to slow it down as well. Okay, so this starts. I'm just looking at the timeline. We have about 2.5 hours of testimony, and it's broken up a little bit. I was going to take a lunch right now since we're at 12 o'clock. I realize it's early for a bunch of you for a lunch break. Some of you just finished breakfast, but it's my lunchtime. It's weird that the judges, not because we're playing catch up, we can sort of decide when we have our own breaks. The first testimony goes for about an hour and a half. We're going to do that after lunch as well as the next one, which is another hour 15. So we've got a full day after lunch to take care of. So if we take a 1 hour break, then we'll be done with day 3. Days 1, 2, and 3 all on our first day. So, and then we can catch up. I've got to do a little more homework just to cut out all the breaks and and everything on the other videos so we can get caught up here the rest of the week. Does that work for everybody? Or for most of you? I'm not going to do a poll because, really it's sort of like I'm king sort of, right? It's not democracy rules here. Any questions? Yes. So those who noticed were paying attention. The hairstyles changed. I think the hair color changes throughout this trial as well. The clothing has changed except for the state, the attorney. Greer, I think his name is. His tie remains the same every day, and I think it's the same knot. He, as Thal mentioned, he's probably, or maybe it was Rando. He slips it off and then slips it back on. It just looks awful. How many days in the trial now? I think we're at day. So we've got. We're on day 3, and they're on day 5. I think that's what it is. So we're a little bit off. This is the Rittenhouse judge. Trying to see if there are any questions here. I don't view myself as king, but I sort of I know when I vote I tend to have a stronger vote because it's I have all the buttons. That's how it works. So we'll see after lunch. Overthrow the king, says Adam. There's mutiny. There's mutiny going on. Even if he burned the remains, the bones do not burn. He had something to do with them. Yeah, I don't think he burned the remains. I think the evidence will show that he just burned clothes, which is suspicious. I mean, steel-toed boots and everything. Those are not things that smell very good when you burn. Levi's don't burn. I mean, they're cotton, so that's a little better. At least it's a natural. But the rivets, the buttons, the clasps, Okay, when you cremate remains, all the soft tissue disappears. You only receive pulverized bone fragments back. It's not ashes. We like to think of it as ashes. Yeah, we're trying not to talk too much about Rittenhouse. Obviously, this is the same judge. We're more of a pickles, not politics station channel here, so we're not going to get heavy into that side. But you can definitely look at Rittenhouse and how the judge behaved to see what type of judge he is. Now, I'm not going to color this trial, his behavior in this trial, with anything he's done before, but it's interesting to see his style. We could be caught up by tomorrow. That's the goal. I just have to do more homework. We're gonna catch up and finish this day after lunch. This isn't a Rittenhouse case. Why was there a mistrial? Apparently the defense failed to, or the prosecution failed to deliver all the evidence. So it was a discovery violation the first time. And that was the mistrial. So they reset it. It never went to the jury. They reset it and, wait, we've got a spam call. Hang on. Hello? Come on. Hello? Oh, they hung up. Man, that was going to be a good one, too. Okay, all right. We'll get the next spam call. I like to put them on the air. Let's see. My liege. Let's see. Judge tries the patience with his prolonged ums and story times. He does talk a little bit. He's older. He's older and he's got a lot of experience behind him. But at the same time, sometimes he can really fire off at the attorneys. And that's what I like. I like the engagement between the attorneys and the judge. Okay. Agree. Some pickles over politics. I don't have any pickles right now. My jar, I thought for some reason I had a jar of pickles. I went in to look at it this morning, just to maybe taste one or two. And I realized that that's actually my jar of hard-boiled eggs that I'm pickling in the spicy maple bourbon pickle juice. Not for this week's podcast, but for next week's podcast. That's going to be my taste test item. Still not sure if I'm going to like it or not. It might be a very bad idea, but we'll see. All right, let's do lunchtime then. Let's do that. Discovery violation is shady. It's hard. Appreciate you guys indulging me on that. I think the judge probably will retire soon. He's had a full career. You should enjoy some life while you can at the end, and hopefully he gets that chance.
Nail it, Murdoch.
Before, whoa, we have to scratch the music just for a second. Before we go to lunch, I wanted to say, for those of you who know, Ivan Victor is here in chat. He's an awesome guy. He's just been phenomenal. He's a great supporter of the channel. I wanted to share, and I will right now in chat as we go to lunch, his YouTube channel, which is actually just a channel dedicated to a little pup named Rebel. I put it right there. I'd love it if, as we go to lunch, you guys all jump over there and just give him a subscribe. It's great little videos with little puppy in there that just doing what puppies do. It's not a puppy, obviously, but a little mini pincher, a mini pin. So, Ivan, thank you so much. I do want to shout it out. I'd love to see him get a whole bunch of subscribers out of this. That would be great. He's been wonderful here on the channel. Both talking to him offline as well, and I'd like to see him do well, as I'd like to see all of you guys do well. So let me know what's happening in your lives. I'm glad to help out if I can. And Ivan, you deserve every single subscription you get. Thank you so much. Let's go have lunch. If you're not going to come back after lunchtime, first of all, you're wrong. You should. But if you're not, please, when you go home, hug the people you love, smile at someone to make their day just a little bit better, and please stay safe till we go live again. Give us an hour. We'll be back at 1 o'clock. Have a great lunch. We'll see you guys. And I didn't have the right picture ready. There we go. Okay, we'll see you guys for lunch.